Good morning.
Good morning.
I want to ask all of us to please turn our cell phones to silent. You may notice board members accessing their laptops, phones, and other devices during the meeting. They are using their devices to access board material for the meeting that are in electronic format only. This is an official meeting of the Medical Board of California. As such, disruptions of the board's business will not be tolerated. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need for the board to conduct its business. Should anyone disrupt the meeting, I will ask that person to conduct him or herself in such a manner that permits the board to transact its business. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand or come forward and you'll be recognized. I would like to request all speakers complete a presenter slip so that I can call you by name at the appropriate time, and that a record of this meeting can be full and complete. However, this is voluntary. Please give the speaker slips to Ms. Cruz-Jones. Ms. Cruz-Jones, can you identify yourself? Thank you. I will do my best to call upon everyone who has supplied the slip for the agenda item and recognize those who wish to make last-minute comments. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconference process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press star 1. You will hear a tone indicating you are in queue for comment. If you change your mind and do not want to make a comment, press star 2. Assistance is available throughout the teleconferencing meeting. To request a specialist, press star 0. Each person will be limited to 3 minutes per agenda item. However, that time frame may be subject to change depending upon the number of speakers on a topic. During agenda item 15, public comments on items not on the agenda, the board has limited the total public comment period for individuals on the teleconference to 20 minutes. In addition, the total public comments for individuals here at the meeting will also be limited to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During public comment on any other agenda item, 10 minutes will be allowed for the total comment period from individuals on the teleconference line and 10 minutes for those in the audience. After 10 minutes, no further comments will be accepted. Each person will be limited to 3 minutes per agenda item. Business services office staff will be assisting me in receiving the public comment via teleconference during this meeting. I want to remind all speakers, please stay on topic on those agenda items and please keep your comments to 3 minutes or less. We plan to end today before 1 p.m. I would like to call the meeting to order and ask that Ms. Cruz-Jones please call the roll.
Dr. Bolat?
Here.
Ms. Friedman?
Here.
Dr. Gonadev?
Here.
Dr. Hawkins?
Here.
Dr. Kraus?
Present.
Ms. Lawson?
Here.
Ms. Lubiano?
Here.
Dr. Lewis?
Present.
Ms. Sutton-Wills? Mr. Warmoth?
Here.
Ms. Wright?
Here.
Dr. Yip?
Here.
Ms. Pines?
Here, we have a quorum. I would like to remind the members again that we will be taking a roll call on all action items. Moving to agenda item 15, public comments not on the agenda. Before we invite speakers to come forward, I would ask individuals making comments to not discuss pending complaints, pending licensing applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications, as they could provide information to the members that is outside the record and in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where the decision is still pending. Board staff is available to speak with you about any pending matter. In addition, the board would like the public to address the board as a whole and not to individual members. Please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action board members can take is to listen to comments and decide whether they want a future agenda item on the topic. No other action can be taken on the item at this meeting. Though this may seem at times like the board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed to avoid compromising the speaker's goals or the board's mission. I have the following speaker slips. Tammy Smick. Can you press
the light on? There we go. How's that?
Perfect.
Hi, good morning. My name is Tammy Smick. I flew here this morning from Los Angeles to attend the advocates meeting this afternoon with Ms. Pines and Dr. Lewis. I was in this very room last year sharing my story, my complete disappointment in the board's handling of my complaint against Dr. Daniel J. Hedrick. And I won't go into detail like I did last year, but because I know there are 2 new board members, and I don't know if they will be attending the advocate meeting this afternoon, I would like to just briefly share my story. I will be talking this afternoon about some things that I think are really important for advocates to discuss with the board with regard to disciplinary guidelines, transparency, and timelines. My son Alex checked into Pacific Coast Rehab in Mission Hospital in Laguna Beach. His goal was to safely detox off of prescription pain medications. He had become dependent on opioids that were prescribed by a pain management doctor. The first night in the hospital, Dr. Hedrick ordered a lethal combination of medications. Alex was given a combination of 11 different medications, and because Dr. Hedrick wrote an order to only check his vitals while awake, he was left unmonitored for more than 7 hours. His first night in the hospital, he died within hours of arriving, and he was found dead. He was already in rigor mortis when the nurse came to check him during morning rounds. I did file a complaint with the board. My complaint took 4 years to reach a decision. It took the board nearly 2 years to even interview Dr. Hedrick. It was a death case. This is just unacceptable that a patient can die and your job is to protect the public, to protect healthcare consumers, and yet you don't even interview the doctor in a death case for 2 years. It was 3 years to accusation, 3 years, 10 months from complaint to hearing. I was not allowed to attend any hearing. Everything was completely confidential. There was absolutely no transparency. And the ultimate decision was a public reprimand. I know that does not follow the disciplinary guidelines of the Medical Board of California, that a doctor can overdose a patient to death and then have a doctor get a public reprimand, for which he was seen on television boasting that he only got a public reprimand. It was the weakest form of discipline, and he was bragging about it on television. Talk about another dagger into my heart. I lost my son. I depended on the Medical Board of California to do their job, to discipline the doctor, to take appropriate actions, which didn't happen. And then I have a doctor on television bragging about the board's decision. And I hope that most of you will attend the meeting this afternoon so that you can hear from the advocates just how important what we have to share is. Thank you for your time.
Thank you. Eric Andrus?
That's Dr. Andrus to you. You guys had that special meeting in December at the Biltmore Hotel, which was kind of a special thing to take care of the business from the previous meeting. I'm just wondering, do you guys know how much these meetings cost to get these rooms and get the telephone lines and everything? I did a Public Records Act request just to find out, because I thought, why are they having it at the Biltmore, downtown Los Angeles? That's a really expensive place. It's a horrible place to get parking. Parking is very expensive. And we talked about this at a previous meeting where I think it was the LA meeting near LAX, and it was $40 for us to park per day. I just feel like you guys aren't taking into consideration how much money you're spending on these meetings. I found out that the Biltmore room and the phones alone cost $4,314 just for that one little special meeting. That's out of line. Who's making these arrangements? There's lots of places that you can get that are reasonable for rooms, reasonable for, for people to come and park. At least here the parking's free. Just a quick update on our website at forpatientsafety.org, and that's with the number 4. We continue to get more and more traffic to our website all the time. Between April of last year and today, we had over 39,000 visitors. Just this week, we received a letter from a DEA compliance assistant at an independent pharmacy website who wrote this to us. Hello, and thank you so much for tackling this huge problem. I have worked in the medical field for over 30 years and now doing medical and legal assisting to the DEA and to track bad doctors and pharmacies. If the majority of people only knew their provider's background, they might be sickened emotionally as well as physically. I am so sorry for all the medical mistakes and misfortunes that led to the necessity of this website, but I have always wondered why this hasn't been done by our consumer advocate groups or law enforcement and provided as a free service. There are a couple of sites that provide disciplinary action information, but they charge you a fee for information, and I look up thousands of providers in my job. Doctors are held to a completely different standard than the rest of the world, which is inexcusable. I believe some of that is from uninformed patients and a feeling like I have, what can one person do to change the system? I applaud your work and say God bless each of you for doing this. I may just have to join your fight. And we get emails like this from people all the time who are coming to our website. As you can see, we're getting a lot of victims coming to us and sharing their stories, which include stories of how this medical board abuses them, and we're getting a lot of good press for it. You need to stop patting yourselves on the back all the time. You do some good work, granted, but don't think that you do all good work and ignoring us, and start working with us to truly make the patient safe in this state. I'm hoping this meeting today really brings something good for all of us to work together, because I'm being ignored a lot. When I send you guys email, I couldn't even get any information about what to expect from this advocate meeting. I sent 3 emails, all of them went unanswered. So you guys need to stop ignoring us and work with us. Thanks.
Thank you. Hannah Ree?
Yes, good morning, board members. I hope you all had a nice evening. Excuse me. So I come on behalf of Black Patients Matter. Good morning. Black Patients Matter calls for the resignation of Dr. Jim Nuovo, CPU Medical Analyst Chief from Sacramento, who spoke yesterday. We are grateful for all his service and hard work in the community supporting patient care, but 26 years working in the CPU is long enough, and it's time for change. He represents an outdated, non-diversified, pre-MIPS, pre-EHR, pre-opioid overdose crisis in Governor Brown's California healthcare history. I would respectfully suggest reviewing his resume on file and noting the lack of racial and religious diversity training experience. As a tenured professor at UC Davis Family Medicine, he likely has extensive such experience and training, but if not mentioned on his resume, then we are deeply concerned Dr. Nuovo feels it is not worth mentioning. After his presentation yesterday, if Dr. Nuovo does not recognize the need to resign, then the problem may be bigger than we thought. Black Patients Matter suggests moving or rotating the CPU in San Diego, for example. A colleague from the CMA Ethnic Medical Organization section was unfortunately the recipient of biased action in the workplace, but she took the initiative and founded the Culturally Competent Mindset, which evaluates, trains, and can certify stakeholders in healthcare leadership positions. I have her business card and would like to submit it to the board. Black Patients Matter requests the opportunity to provide a presentation on the ongoing racial disparity and how the board can help in closing the gap. As a participant, again, I mentioned yesterday, in the California Black Health Network and follower of Pastor Shields at Progressive, I can say that with certainty we have a significant increase reaching epidemic proportions in autoimmune diseases such as sarcoidosis, lupus, glaucoma, blindness amongst California African American patients. We call on the board to stop contracting with medical experts with no training in racial and religious diversity as evidenced on their resume, as well as to diversify the DCA's Office of Investigation so as to close the morbidity and mortality gaps amongst Black patients. I'm currently defended in a 27-page accusation, 21 causes of action for being a hospital Medicare whistleblower. I have here copies of published studies and reports of the importance of racial diversity in healthcare published at institutions such as Stanford, Berkeley, an Oakland nonprofit. The importance of racial diversity in healthcare so as to improve the health of Black patients, because Black lives matter too. Thank you.
Thank you. Connor Finney.
Hello, my name is Connor Finney. I am the patient's rights advocate with Consumer Watchdog. I just want to start my comments by applauding the medical board for its ambitious and necessary death certificate project. Consumer Watchdog and the Center for Public Interest Law wrote a letter today to the board in support of this important project. As America continues to grapple with the opioid crisis, the MBC has taken the necessary steps to hold negligent overprescribing physicians accountable. As has often been the case, the victims of opioid overdoses have not received justice for negligent overprescription. By embarking on this initiative, the MBC not only does its due diligence to give justice for negligent overprescription. By embarking... Sorry, lost my place here. By embarking on this initiative, the MBC not only does its due diligence to do right by those who have died of drug overdoses, it protects future patients from being victimized by negligent doctors. Patients who are addicted to pills will never complain, and that's why this initiative is so important. The medical board has also taken an important first step in opening up a new platform for concerned Californians. The interested party meeting that will follow this meeting will be a great venue for patients and malpractice victims to voice their concerns over the board's effectiveness. I urge the members of the medical board to not only support an initiative that would make interested party meetings such as this a regular event, but I also suggest that you take the suggestions and complaints of the public at these meetings seriously. The board should take this feedback seriously because there is a lot the board can do to improve outcomes for California patients. As I mentioned in the enforcement committee meeting yesterday, only 14% of complaints were investigated in fiscal year 2017 to 2018. That's down from a median of 18% over the past 10 years. In spite of the 58% increase in complaints in the past 10 years, there has only been about 11 more licenses revoked per year. The time it has taken to conduct an investigation has almost doubled, and the investigation process is opaque to patients. It is difficult to find the status of investigations, and investigators will close cases without even interviewing the patients in question. I also urge the board to support a patient's Bill of Rights. Consumer Watchdog and other patient advocates have offered these reforms before, but have received no response from the board. I can offer the board the language of these reforms today if you wish. In conclusion, the board needs to change its policies to allow more communication and transparency with patients who have filed complaints, as well as to do more to keep pace with the ever-increasing amount of complaints the medical board receives. It is the board's duty to protect California's patients, and it needs to step up and do more to conduct more investigations, conduct them thoroughly, and conduct them in a timely manner. Thank you for your time.
Thank you. Wendy Sue Ketch.
Hi, good morning.
Good morning.
My name's Wendy Connect. I filed a case with the medical board in July of 2016. That case was closed without investigation in October of 2016. I sued the doctor in November of 2016, and my case settled out of court for $1 million, his policy limit. My case has brought to light several issues with the medical board policies and procedures that I would like to address with the medical board. 1, the procedures by which the medical board conducts its investigation lacks fair and thorough research. For instance, a simple Google search by the reviewer would have produced evidence of the use of a device that was contraindicated by the FDA, as well as a very strong conflict of financial interest. I was never interviewed for that investigation, and the doctor's word was never challenged. This has put other patients now in grave danger. Regarding settlement disclosures, right now, if you look up that doctor that I settled with, it will say no records under settlements. I was really happy to hear that Kim Kirchmeier told me yesterday that you'll be amending this language so that it will now have a qualifier that says this doctor may not have met the reporting criteria, something to that effect. But also, I do believe that the reporting criteria should be explained as well. Most people would not know of the current requirement for a doctor that a doctor must have 3 to 4 settlements before in a 5-year period before it's public. So I think that policy should be right there so people understand that. It's really obviously not a service to patients, and I urge the board to support legislation that amends this policy. Every patient has the right to know if their doctor has any settlements over $30,000, which is the reporting requirement to the medical board. Regarding investigations, patients really do have the right to know about the state of their investigation. I'd also like to make a suggestion that all communications be accessible on a mutual website for patients and the parties involved, even the doctors. This could be modeled after other government sites, such as the Patent and Trademark Office, where all actions are recorded by the examiner and accessible to the filer, so they know exactly what stage their filing is in, what the next steps are, and the status and the planned actions. That would be a real service, I think, to patients. It's fully transparent, and it's a great government model to follow. In the meantime, investigators really need to update patients periodically with information, and patients shouldn't be kept in the dark. And there's definitely communication should be a priority. Lastly, but most importantly to me, I would like to suggest that the board address the problem of conflicts of interest. All patients have a right to informed consent.
Please conclude.
Okay. I'm just going to say that anything over and above a certain amount of money, a reasonable amount, should be a legal matter that doctors should report, and that I think it would make a valuable difference in identifying doctors that are guilty of overprescribing dangerous drugs and inappropriate drugs or devices, and many of whom are in the pocket of drug companies. How's that?
Thank
you for your time. I think I skipped a few things, but that's okay. Thanks.
Mary Ann Hollingsworth.
Good morning. My name is Marion Hollingsworth, and I'm a patient safety advocate with the Patient Safety League and the Patient Safety Action Network. What I would like to bring up to you is the issue of the use of concurrent and superseding disciplines when dealing with doctors who have had prior disciplines. An example is 2 in San Diego recently were given their second disciplines while they were still serving their first probations for violations that you found had merit. Instead of having another 3 or 5 years added to their probation, both were allowed to serve it concurrently. One was superseded, so he had an extra year, so I think he has a total of 7 or 8 years now on his probation. But the other one was just allowed to serve it concurrently, and this was for addiction issues. And so you have to wonder, how does this serve the patient's safety if they're allowed to have their violations, their probation served at the same time? This seems to be a new pattern that's emerging. We hadn't seen this before in a while, but it's to have 2 at the same time. It looks like that the board is being a bit lenient when it comes to doctors who have clearly violated state standards. I hope you will take this seriously so we won't see any more concurrent cases come across in your alerts. Thank you.
Thank you. Are there any comments on the phone?
Are there any comments on the phone?
Susan Lauren, your line is open.
Go ahead, caller.
Is that me?
Yes, go ahead, please.
Oh, you can hear me, right?
Yes, we can hear you.
Right. You can have your advocacy meeting today and try to tell people how your system of protecting your self-interest works. Doctors can have board certifications up the wazoo, but the truth is a surgeon mutilated me alive. The truth is I didn't ask for it. I didn't need it. I wasn't lazy, fat, looking for an easy way out. I was at Top Fitness and was told I needed breast reduction. I didn't deserve to be hacked up because I wasn't 22 years old. Plastic surgeons do not have carte blanche to remove whatever body part suits them, but you give it to them. I was a fit, active, healthy, happy, successful businesswoman who loved my life, and the world was my oyster. But since the offending surgeon went on a contraindicated, unwarranted battery episode while I was helpless and unconscious on a table in his privately owned ambulatory center, a place without any checks and balances, with his wife as the office manager, a fact that was hidden from me. Since then, I've been housebound, like a prisoner. My quality life is over. I don't have agoraphobia or fictitious disorder. I didn't want to look worse naked. I wasn't on a downward spiral. I wasn't a dabbler or all the lies that they tell. The truth is I was sliced and diced up over 60% of my body against consent. Hundreds of people have seen the video showing that this guy stabbed me a multitude of times into my muscles, sucked me to the bones. He took half of my healthy breasts. These people, including my legislators, have read the letters from the good doctors who have gotten to know me and examined me in depth since the surgical battery. But your board and the AG's office have no excuse for not doing the right thing here, none. And you're showing wanton disregard for my life and those that will come before and after me. The reality show plastic surgeon that has reviewed cases for your board for decades, he came and lied at my trial, slandered me, perjured himself. He said the atrocities done to me were done exactly as the Medical Board of California would want it to be. I lost that trial. That leaves me at risk for homelessness because I can no longer do my work that I'm passionate about or any normal work. The guy who works for you makes $9,000 per depot, and his depot for my case said he did at least 100 depots by 2015. That's nearly $1 million just for that. Then add on all the other costs of being an expert witness. Doctors and lawyers tell me your fellow was known as a whore for the insurance companies, and having him work for you is corruption at the highest and worst level. I had my knee sewed up by a plastic surgeon when I was 7 years old. That was a good thing for a plastic surgeon to do. But surgeons who suck out fat, a scientifically proven, risky, unhealthy thing to do, are not the ones to decide cases against plastic surgeons. And this racket needs to change. Now, I want to know, what do you suggest I do now, since you have blocked me in carrying out my duty as a good citizen to protect others? Your board has closed all doors for me for this case, and you're covering up a horrific crime.
Caller, please conclude.
So what's my next step? because I am a victim of perpetrators, including your board. I'm not a victim in the way I comport myself.
Caller, you
but
reached 3 minutes. Please conclude.
Well, I need to know an answer today in the advocacy meeting or somewhere of what I can do, because you don't let a guy pack you up and do nothing while others are getting.
Thank you. Are there any other comments on the phone?
Yes, our next comment comes from Kenmore Hill. Your line is open.
Hello, my name is Kamar Gill. I'm calling from Fresno, California. And the purpose of my call is to, speak on behalf of a physician's perspective, because I'm a licensed physician. And it seems like most of the speakers who preceded me have made comments to the effect that physicians are not being disciplined properly, or the board is not doing enough. I can tell you board is doing probably more than enough. Where board is lacking, however, is that its choice of experts is not that great. It's not paying its experts much as would be needed to be able to prosecute physicians and be able to review those reports in a timely manner. I mean, if you're paying an expert $150 or $200 an hour to review a case or a report, on the other end, defense attorney is paying $600 or $700 an hour to an expert. Definitely, those reports, when they are prepared, are going to be much better than whatever board's experts are going to draft. So that's something to look into. Is there's a cost of prosecuting physician, and a more budgetary allowance should be made available. And on the same note, I would want to concur with one of the previous commentators regarding the expense associated with medical board meetings. I know the contract for today's meeting was drafted somewhere earlier this month, and it is my understanding it's pretty expensive to run the show here in Milpitas, in the location you are at. So I was wondering if some of that money can be actually used to paying the experts and paying the people who are actually prosecuting the physicians versus spending on board meetings. I think there are cheaper venues available that should be explored, and hopefully if that is done properly, then we could have money left in the pot to actually fund the consumer protection. Thank you.
Thank you. Are there any additional phone calls?
I show no further questions or comments.
Okay, thank you. Let's move to agenda item 16, an update on the Board of Pharmacy. Ms. Sodergren?
Good morning. Thank you very much for the opportunity to provide an update on the Board of Pharmacy's activities. I'd like to first start by thanking your executive director for her collaboration as we worked through the challenges and the patient care issues that arose out of enactment of AB 1753, which is the Controlled Substances Security Form issue. The information sharing and the joint statement that we provided, I believe, provided reassurances to both of our licensees. Earlier this week, as a follow-up to that, our board did vote to support AB 149, which should provide a permanent solution. I believe your board took similar action as well, so thank you. Our board remains focused on the opioid epidemic. We are doing education and enforcement-related activities. Our board hosts prescription drug abuse training events offering free continuing education to attendees. The board's next event will be held on February 23rd in Fresno, and your executive director will be attending the event. As part of our consumer education campaign, we will be using 5 billboard sites throughout California, which are intended to raise the awareness of prescription drug abuse epidemic. The effort will be further supported by the board's consumer education information on its website. We look forward to collaborating with your board in the hopes to co-sponsor another education forum that will be focused on the epidemic, bringing together, again, prescribers and dispensers. The board also recently approved a policy statement supporting the role of pharmacists in providing medically assisted treatment, MAT, under collaborative practice agreements. And I can provide a copy of that policy statement to your executive officer should that be of interest to you.
Another initiative underway is the board is also looking at steps it can do to improve emergency response as destructive fires and many other things are impacting consumers. We're looking at what's been working in emergency response and where there's opportunities to provide better care to patients. In that vein, as part of our efforts, we will be sponsoring legislation this year that will create a very limited exception to the controlled substance prescription forms that are required for patients. It will be mirrored similar to the provisions under the law specific to exceptions for terminally ill patients, but will be far more limited in scope, and we're happy to provide a copy of that language once it's finalized to your executive director as well. With that, I'll just wrap up, but I will say that we look forward to continuing to collaborate with your board and trying to work to make California a better place for its patients. So thank you.
Thank you, Ms. Sodergren. Are there any comments or questions from the members? Yes, there is a comment. Yvonne Chung, please.
Good morning. Excuse me. Good morning. Yvonne Chung with the California Medical Association. We wanted to just bring an issue to the attention of the board. Like the nation, California has been faced with a serious healthcare dilemma: how to prescribe controlled substances safely and effectively to relieve pain, while simultaneously reducing the risk of prescription medication misuse, addiction, and overdose. We've heard a lot about that at this meeting. CMA has been supportive of efforts to address the complicated issues related to prescription opioid misuse and overdose, and has advocated for a well-balanced approach to opioid prescribing and treatment that considers the unique needs of individual patients. We have been engaged in addressing the opioid crisis, and we recognize that both prescribers and dispensers have a professional and ethical obligation to assess its role in reducing prescription drug overdose and addiction. With that said, CMA is concerned about the impact of arbitrary and disruptive pharmacy policies that are having an impact on the patient's ability to access their legitimate medications and in a timely manner. We've been receiving inquiries from concerned physicians and their patients that their prescriptions are being denied or held up pending additional documentation, which can take significant amounts of time to comply with. We've been formally tracking these inquiries since November, and we've received about 24 calls from physicians. And some of these denials are occurring in rural areas that offer very few alternatives for patients that need access to their legitimate medications. So just a couple examples. We had a call from a patient who told us, and we verified this with the pharmacy, that the pharmacy said that starting January 1st, they would not fill any prescriptions for controlled substances in excess of 50 MMEs, regardless of what the tapering schedule was. And the pharmacist was unable to tell us if this was a local policy specific to that pharmacy or if it was a corporate policy. Physicians have also been asked for extensive documentation, such as treatment agreements, medical records, tried and failed therapies, diagnoses codes, that we believe go far beyond corresponding responsibility. This also raises the issue of medical records retention, that if this information is provided to the pharmacy, what exactly is being done with it? Where is it being kept? Is it being maintained in a manner that is compliant with HIPAA? So we just wanted to bring this issue to the attention of the board. We are committed to working with the medical board. We've talked to Ms. Kirchmeier about this and the Board of Pharmacy. We are hoping to arrange a convening with pharmacy corporations and other stakeholder groups to try to reach some kind of agreement about some community standards regarding how pharmacists conduct their corresponding responsibility in this manner, and we'd appreciate the board's support. Thank you.
Thank you. Are there any additional comments from the audience? Are there any comments on the phone?
Yes. Ludmila Parada, your line is now open.
Hello. Good morning. I know that in the view of the medical board and the Attorney General's office, my husband was nothing but an unfortunate mistake, another statistic in the big scope of things. For me, my husband was an athlete, a scientist with almost a dozen patents to his name, a member of Big Brothers of America, a man that through sheer intelligence and hard work escaped a life of poverty in Mexico to earn a full scholarship to complete graduate studies in engineering at the University of Michigan. Now he's paralyzed for life, missing portions of all his limbs,
depending on others to be fed and dressed, all because his doctors repeatedly disregarded his pleas for advice. Or to put it in terms you will understand, to constitute depraved indifference, the defendant's conduct must be so wanton, so deficient in a moral sense of concern, so lacking in regard for the lives of others, and so blameworthy as to warrant the same criminal liability as that which the law imposes upon a person who intentionally causes a crime. Depraved indifferences focus on the risk created by the defendant's conduct, not the injuries actually resulting. To ignore classic symptoms of severe sepsis repeatedly and maliciously, as his doctor did, is accepted medical practice according to your office. Or to give you an easy to understand analogy, imagine that someone you love is severely wounded and injured because a driver was careless. The driver's insurance does not pay the victim a cent. The victim's family has to absorb the full medical cost of this tragedy. And the district attorney does not only refuse to prosecute the driver for vehicular assault, but even fails to even send the driver to traffic school or even put a point in their license because it will be too much work. Thankfully, my husband's case has gotten far more interest from ProPublica and the Consumer Watchdog than it ever did from your office and the NBC and the Attorney General's office. Now his case is known by thousands of patient safety activists across the nation who believe that it is a cause of indignation that you get far more transparency from your pickup Vietnamese restaurant than of the doctor who makes life and death decisions for you. For being a consumer protection agency, this board has the victim, the consumer, at the lowest of its considerations. My husband's injuries are permanent, yet nothing happened to the doctor that harmed him, not even a class or even a note on her record. And this happened not only to us, but to over 9,800 patients a year with no transparency nor accountability. I bet you don't even investigate the vast majority of complaints because your numbers support as much. So here I question, if you don't protect the patients, then what is your purpose then? To further limit the access to justice? Thank you.
Thank you. Are there any additional calls?
I show no further comments.
Okay, thank you. Before we move to our next agenda item, I want to take a moment to recognize Virginia, known as Guinea Harold. She's the former executive officer of the Board of Pharmacy. Ms. Harold retired on December 31st, 2018, after 39 years of state service, 29 which were on the Board of Pharmacy. Ms. Harold is the executive officer, was the executive officer for the last 12 years. I want to personally thank you for your partnership with the board over the years, and especially as we were going through the opioid crisis when it was at its highest peak, and all what we did to collaborate and come up with things that were going to protect the public. Our two boards held a joint forum as one of the things that we did in 2013 regarding the opioid crisis that provided extensive education to hundreds of physicians and pharmacists. In addition, Ms. Harold has worked closely with our board over the last several years on legislation, joint protocols, and numerous other projects. We want to thank her for her service and wish her the best in retirement, and I would like her to come forward as we have something to give her and let her have a few words and she wants to share.
How do you get that microphone?
Us and the work that we do here at the board, and we would just want to thank you for your
It appears that we have some more work that we need to do. I find it really interesting to sit in here and listen, and I always like coming to your meetings because I get a slightly different. Somebody's going to get my back. I'm sorry. Stand back here. Oh, okay. I feel like I'm storming the microphone. You learn a lot by going to other board meetings, and you pick up things from each board how you do it. I think, though, for us, I think we have a long-standing relationship with the medical board because our prescribers and our dispensers are so closely intertwined. And it does sound like it's time for us to have another joint meeting. Kim and I had been hoping to try to start, in fact, we did have one meeting at one point to develop an agenda, because this was not just talk it through. We had national policy setters early on in the area of opioids while it was still emerging as a significant problem, or at least being discussed in public forums. So I certainly think that it's time to continue those discussions, because it's time to move on to the next iteration. We have patients out there addicted that we can't seem to take care of adequately, and we can't just drop them. And it's also a prescriber and a dispenser problem. And we also need the prescribers and the dispensers to better understand each other and better use cures, because cures actually will help them do this. At the end of the day, California is the most populous state. We've got a lot expected of us. We have wonderful resources that other states don't have. Our public should be well cared for. And listening to each other and communicating in this manner is good for our continuity of care that we can develop. So this means a lot to me. I feel like I'm leaving a job kind of left undone. It does look like I'm going to be working in the area of MAT, or medication-assisted treatment, for a while, to kind of help some of that funding that's being thrown at medical care to help make sure that we've got it going to patients adequately, because there just aren't enough people trained to provide it at this point. So there's many challenges, and it sounds like, again, we need to have another couple of discussions on corresponding responsibility, which is an important thing for us to do. To a pharmacist, we don't want them to just be dispensing machines. We truly want them to evaluate the quality of the care, and we will discipline them if they don't use that judgment that took them 6 to 8 years minimum, plus residencies, to gain. So anyway, thank you all very much.
Dr. Gananadu?
Oh, Dr. Gananadu.
Sorry, I can't let you go without hearing from me. And you were very helpful, and actually worked with Kim and I so well in the past several years to really bring the both boards together. We truly appreciate your help, and we'll work with your person who is following you there right behind you so closely. I think we're all in there for the best practice of medicine.
And I appreciate your openness and your willingness to meet with us, because I've had several board presidents come to meet with you and me and with the executive director. So that has been very important, and I hope the outcome has really benefited California's patients, because that's really where it is.
Thank you.
Thank you very much.
Thank you.
Thank you.
Let's move to our agenda item 17, discussion and possible action on the petition for pursuant to Government Code Section 11340.6 to amend 16 CCR Section 1366.31 regarding approved medical assistant certifying organizations. Ms. Webb.
Thank you. Members, if you want to turn to item 17 in your book. The board received a request to review the requirements for medical assistant certifying agencies. And just to be clear, medical assistants are not required to be certified in order to perform their technical supportive services. If they are certified, they do not have to be certified by an organization approved by the board unless they are going to be training other medical assistants. But obviously, many agencies would like to get board approval, so they have that additional recognition. Here, the National Health Career Association has asked the board to consider striking the requirement that medical assistant certifying agencies be nonprofit. When this regulation went through many years ago, the purpose was to avoid approving agencies that just had a profit motive and weren't concerned with the actual quality of the training. But the National Health Career Association has asserted that for-profit entities are actually just creating nonprofit arms to avoid that barrier, and that being nonprofit is not stamp that they are a good quality organization and that more needs to be looked at. So instead, they have suggested that certifying agencies be accredited by the National Commission for Certifying Agencies, NCCA, and undergo psychometric evaluation. I did some looking into this, and the NCCA is a well-respected accrediting agency that is referenced throughout several statutes and regulations impacting different state agencies and in a number of different disciplines. And it's worth considering. It may not be necessary for certifying organizations to undergo a separate psychometric evaluation because this may already be a part of the NCCA approval process. So I've reached out to them to get information regarding that. And so what I would ask is that the board approve this request in concept and permit staff to bring some proposed regulation language back for consideration. If we do it for medical assistants, we should also do it for midwife assistant certifying organizations. And so we need more time to bring language and address what's really necessary to make sure we have quality organizations approved by the board. And so I would ask for a motion to approve the request in concept.
Can I have a motion?
Yeah, I make a motion to approve, and I also want to comment that many organizations are going that route because CMS did that. That's the Medicare did that. So they do have approved for-profit entities, unfortunately, but they do. And so does the LCME, the medical school approving organization, approved a first for-profit medical school in Sacramento. So this is the trend. It's some kind of a legal liability they looked at if we're not going there. So it was an issue. So as long as they are, the important thing is who accredits them. You mentioned that National Accrediting Agency is a decent place. If they do that, I don't have any problem.
We have a second. Oh, Dr. Warmer? Mr. Warmer.
I'm not sure that I understand the need for an either or in this situation. As far as I absolutely agree with the idea or the concept of a certifying agency to consider these training programs, but why does that also require that we do away with the nonprofit? Is there a reason?
Well, it's because for-profit entities are simply creating nonprofit arms to avoid the barrier. And so the reason why it was put in there is to address concerns about quality, that they're actually putting together adequate training programs and not just running a certification mill.
I understand that, but what I'm saying is that this doesn't do anything to change that other than it adds the certification. I believe that we could do the addition of the certification process without striking the nonprofit.
I think the concern is that if you can address quality and not put a barrier as to who can perform it, that would be the appropriate route.
Dr. Gananadev?
Yeah, just to answer Mr. Warmuth, he has a good point. I had the same issue when LCME took out one of the requirements that the parent company of a medical school must be or should be or shall be not for profit. They were very concerned that the way the trend is going in accrediting agencies where the Department of Education is approving for-profit entities, and these entities like us or entities like LCME, when they put that restriction, there might be some legal liability. I think we need to look at quality. I have an aversion to for-profit entities like you do, but I think it was an issue which came up multiple places.
Oh, Dr. Bola?
I would just like to understand a bit about the certification and what we're certifying, and if the board's role of whether it's for-profit or non-profit. I think, and you did a beautiful job a couple of board meetings back to talk about the role of the medical assistant. And so that certification process, which if I'm reading it right, it is to say that a medical assistant with 2 years of training can serve as the part of this, can serve as a trainer of medical assistants, right? Is this certification for that person to teach another group of medical assistants, or is it certification of medical assistant training schools?
This is not certifying schools, it is certifying the individual. And it's so that you can have a medical assistant in your office train other medical assistants. Otherwise, they can't.
Okay, and then if the board is going to put a stamp on that, the issue I think that you raised at a couple of meetings is the role of the medical assistant within organizations, large and small, and the variation in quality. Is this move going to improve, I guess, the variation in quality? Is that part of this movement, that if we were to say that this is a curriculum that would not get physicians in trouble because they don't realize that a medical assistant can't do certain things, such as giving IV medications and so on, is that going to be addressed at a later date? Or does this just simply say tax exempt versus a not-for-profit for profit? Is that what this scope is limited to?
This isn't... Part of why there's so much variation for medical assistants is because they don't have to have formal training.
Right.
They can be trained on the job.
Yes.
They don't have to go to school. And many do go to school. This does not address their school.
I see.
This addresses the individual coming out of the school. They have to meet certain requirements, and they have to take a separate test. So the certifying organization is what we're talking about.
I see. So we eventually, like anything else, we may have a couple of different tiers of qualified people that are working side by physicians.
Yes.
And that's a very important point, because many people are not quite understanding, I believe, the differences between an MA, an LVN, an RN, and so on. So that, I think, is, if we go down this road again, to maybe perhaps really reinforce the idea of what a medical assistant is and isn't, and then the downstream consequences of the cost of someone to get that MA and then go for certification will also be something, particularly given that many of these individuals that are medical assistants are people from the communities of color, and it's costing them a lot of money. So that's something for us to just keep on our radar. Thank you.
Dr. Kraus?
Thank you. The motion on the floor is to request staff to investigate and report back for discussion and decision at a subsequent board meeting, which I support. And the issue is that we're being petitioned specifically to strike the word nonprofit from the regulation. So in reporting back and investigating, I would also like for you to touch on the differences of nonprofit versus for-profit in terms of how that will ultimately influence consumer costs. We've got a $3.3 trillion healthcare bill in the United States, and quite frankly, I believe that a small minority of that goes to healthcare. A lot of it goes to profit, administration, regulation. So if you could also look into whether or not there are increased costs downstream as accrediting agencies become for-profit. The other thing I would like for you to investigate is what benefit in yours to the public if we stick to the nonprofit status. nonprofits have certain obligations to the government and fall under certain regulatory rules that may not necessarily apply to for-profit accrediting agencies. So what do we give up by striking nonprofit in this circumstance? Thank you.
Thank you. Dr. Yip?
Just to echo the other comment that when we do the research, we can find out in existing which and who and how many schools are so-called doing MA training. Even in my area, I have problem finding those schools. I don't even know where to call to find MA. In the past, you have MA school. Now it seems that they're not there. Second is that what is the implication beyond the first step for profit, non-profit, as far as if we're going to put a head, have the authority to so-called grant it, we really need to look into the details. There's so many different specialties, dermatology, surgeons, family practice, what the role is, what the training is, so that these people get their money worth. You see a lot of these so-called non-for-profit organizations come and take a course for 8 weeks and then you go out and get a job. And I find a lot of those MA actually, what they learn is actually they dump you into certain doctor's office to 200 hours of certification. Really doing the training for them. So I think we need to look into the details how they are trained, how they certify, and looking forward so that they won't feel that it's one of those schools that produce certifications. So thank you.
Thank you. Any other comments from members? I have one slip here from the public. Hannah Reed.
Yes, hello. Black Patients Matter here. So we would, on behalf of Black Patients Matter, we would like to see the medical assistants at some point be required for accreditation and certification so as to maintain healthcare standards, and also be required to undergo, for when they become certified, it really is a great opportunity for them to also undergo training in racial and religious diversity as well, because they are part of a healthcare team. And most members of the team these days, especially in a hospital setting, for example, are all certified in one way or another. And in my own experience working with MAs, there definitely is a difference of quality in terms of MAs that are certified and those that are not. However, Dr. Bolat brings up a very, very good point, and that is that for a lot of MAs who are trying to find their way in life, they're quite young and come from working class immigrant communities, and so the cost of certification would definitely be could be a deterrent from them entering the healthcare field. So it is something to consider, and hopefully there would be a solution as far as cost containment for them, sort of thing. So thank you.
Thank you. Are there any additional comments from the audience? Any comments on the phone?
Any comments?
I show no comments.
Okay, thank you. Ms. Cruz-Jones, can you give us a roll call?
Dr. Bolat?
Yes.
Ms. Friedman?
Yes.
Dr. Gonadev? Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Ms. Lubiano?
Yes.
Dr. Lewis?
Aye.
Mr. Wormuth?
Aye.
Ms. Wright?
Yes.
Dr. Yip?
Aye.
Ms. Pines?
Aye. Moving on to agenda item 18, presentation on outpatient surgery settings, Ms. Kirschmeyer and Ms. Alameda.
Well, good morning, members. As most of you may remember, at the last board meeting, Dr. Yip had actually asked for a presentation on the outpatient surgery setting program, and we've done this a couple times, and it's always good to be aware of kind of what this program is and what we do and how we're interactive with this program and how we run it. So several years ago, there was actually a court decision that actually greatly changed our role in this whole process. And as you may know, that the law requires that if a surgical procedure requires anesthesia to be administered in doses that have the probability of placing a patient at the risk for loss of patient's life-preserving reflexes, then the surgery must be performed in an accredited, licensed, or certified setting. A setting that wants to be accredited must be accredited by an accreditation agency approved by the board. So far, the board has approved 5 different accreditation agencies. These agencies must go through a renewal and approval process every 3 years. So during this renewal process, the agency must provide the board with a document outlining how they comply with all of the requirements of the law. And we won't be going over it, but at the end of the presentation is a list of those requirements that are required in law. In addition to those requirements, the accreditation agencies that we approve also have their own requirements that they mandate for these entities as well. They're not in law, but they're things that for that accreditation agency they require. Board staff review these documents and determine if there are deficiencies in compliance with the law, and then we request additional information from the agency. Again, it's very important to note that the board does not issue the facility accreditation, but we actually approve the accreditation agency that oversees those outpatient surgery settings. And so Ms. Alameda is going to walk us through kind of the evolution of this program, how we got to be where we are. And it's kind of an interesting program with our outpatient surgery program because part of it is handled in our licensing unit and part of it is handled in our enforcement unit. And so we'll be going over those different processes.
Good morning. So in 1995, the program was enacted, and at that time, the board approved 4 accrediting agencies. So effective July 1st, 1996, users, a setting that uses anesthesia at a level placing the patient at risk of losing their life-preserving reflexes has to meet Health and Safety Code 1248.1. In 2000, there was a mandatory reporting where the settings had to report any death or transfer of a patient to a hospital that had to stay more than 24 hours to the board. And then in 2007, all of the settings where any portion of the setting was owned by a physician had to be accredited and not licensed by CDPH. As of now, the board does have 900 settings that are accredited, and there are a total of 1,300 in our database, which includes those that are with CMS.
So, and what changed that really? This was the huge change in this program for the board was this case called Capon versus Shuri. And the court case, there was no law change. It's interesting about this. There was no law change, but this court case came down and basically said that even if there was 1% physician owned in these facilities, it should be overseen by the medical board because it was a physician involved in it. And there's a lot more to it. And Carrie's probably going to kick me over there. But so that was kind of the crux of it. And so the CDPH attorneys at the time, when they were looking at this, really came down. We had a meeting with all of them. And ultimately what they determined is that the California Department of Public Health wasn't going to basically license any entities that had part physician owners in it. Those would have to be under the medical board for being accredited. And so we went from probably having, who knows, even back then, it was probably anywhere around 20 to 30 facilities to now having this large number of about, 900. And they, on the other hand, went from having this large number down to a very small number. So it's been very interesting how it's progressed.
No, it's okay. In 2011, there was significant changes as a result of SB 100 that was passed and effective January 2012 that required significant changes in outpatient settings. For the medical board, it required a database that posted information on regarding the settings, including their accreditation status, action, owner information, accreditation agency information, effective date, and expiration date. It required the board to evaluate the accrediting agencies, evaluate complaints against the accrediting agencies, and maintain inspection information and put all of this information on our website. For the settings, they had to post the plan of action to the public view and remove certification if revoked, surrendered, or denied, disclose full report of denial if applying to a different agency. I'm sorry, maybe adverse event reporting to CDPH. They had to submit a plan to the accrediting agencies for procedures and protocols to be followed in the event of a series of complications. all have to be inspected, and they have to comply with the corrective action that they receive from the accrediting agencies. So for the accrediting agencies, they have to conduct inspections or investigations of prior history of the settings prior to accrediting them. They have to inspect the settings at least every 3 years. Upon receipt of a complaint from the board, they have to inspect the setting within 5 days. If there is an immediate risk or other complaints, they have to report findings to the board within 30 days. They have to notify and update the board on all settings that are accredited. They have to notify the board within 24 hours of any reprimand, suspension, revocation, placed on probation. If there is a revocation, they also have to send a letter to the setting saying that they can no longer perform any procedures. So in 2013, we had some more improvements, and this was as a result of the board sunset review and discussion regarding our role and the things that needed to be changed. There was a task force that was established, and what that task force did is they, looked at the board's the database, the system. The settings, they recommended improvements, the process. They reviewed all of the laws and regulations, and then they, came up with recommendations to just overall improve the program. So now we're in 2016, and as a result of SB 396, this was allowing surgery settings to obtain 805 information on physicians, dentists, and psychologists. It allows for the inspections, and then after the initial inspection, they can perform unannounced inspections if needed. It requires peer review every 2 years. And then now in 2018, there was some more discussion during the sunset review process, more changes that we wanted. But the only change that we got was regarding adverse event reporting, which Kim is going to cover in a little bit. So this is a picture of what is on our website and of the database. We are looking at making some changes even though this works really well and it provides a lot of information. It's the inspection reports, corrective actions, if someone's on probation, owner name, everything about the facility. We are looking at changes to require the settings to actually post the information, be able to pull reports, notify the board if there's any missing information, so we can, turn around quickly and reach out to the agencies and say, we didn't get this information. So this, again, just a picture of the database and how we can go in. You can query by the address and the name of the facility, and it will tell you who accredits that setting. This is a report of everything that is about the setting, the name, the address, their status, when the effective date of their accreditation, their last inspection. This is all, public and on our website. This is an example of a report that we receive from the settings, and if there's any corrective action, it is, listed on the setting. When we do get that, then we obviously are looking to, make sure that that is corrected and that we get an update report from the setting. So right here is a side-by-side comparison of what the roles and responsibilities are of the accrediting agency and then also the medical board. This just gives you an idea of when these inspection reports come into the board, if there is a deficiency, the path that it takes. If there's no deficiency, the path that takes. All of this information is on our website. Okay, I'm sorry. So I'm going to go through this. So for a deficiency that is a yes, it is posted on our website. Then you can see that the patient safety and physician conduct related, then it would go down and it would go to enforcement and it would handle, follow the complaint process. If there is a no, that we will be monitoring the corrective action plan and that outcome of that report. If it's not received, we will be following up with the accrediting agency to make sure that it's, looked into and resolved. And then down at the bottom, you see that if it's a yes, we post the corrective plan and the outcome of that report. If it's a no, we're going to contact the accrediting agency and follow up and see what's going on. So now I'm going to turn it over to Kim to talk about the adverse.
So in 2013, we actually requested that the adverse event reports be sent to the medical board. So as April had said earlier, it was when the first legislation came in, it was that adverse event report went to the California Department of Public Health. But there was this change in who has authority over these entities, and so they were getting adverse event reports that they weren't sending to the medical board. And just in a minute, I'll be showing you some statistics, but in 1 year, I think we got 12. And it's normal for us to get about 150 now. So you can see that there was a big difference, and we weren't getting the information that we really knew that we needed to be getting from these facilities. So part of the task force, Dr. Gonada was actually on that task force, was putting forward a change to require that the medical board get this information rather than it coming and going to the California Department of Public Health. So we changed that, and it was a huge, huge public safety issue for us. So that outpatient surgery setting, they actually have to report these events to us within 5 days after detection, or if the event is an urgent or threat to a patient welfare or safety, then they have to report it within 24 hours. So these are the adverse events that have to be reported, and this is the new change that as of January 1st of this year, that these entities now have to report. And there's a couple things that are big changes. I'm going to go over these real quickly because I think it's important for you to know when these individuals have these events, these are what have to be reported to the board. So if there is a surgical, or other invasive procedure or event, and that includes if it's on the wrong body part, if it's on the wrong patient, if there's a wrong surgery or other invasive procedure performed on a patient, so it's the wrong surgery now, the type of surgery, retention of a foreign object, death of a patient during or up to 24 hours after admittance. And then this was the big change. Now, April spoke earlier about a transfer report having to come in. That actually is a de-identified one that's under Section 2240 of the Business and Professions Code, and that actually goes over to OSHPAD. It's truly only for data collection. It's not to give us the information. So this was a big change, and we worked with interested parties to put this in, and that was the transfer of a patient to a hospital or emergency center for medical care for a period exceeding 24 hours following the procedure. So now that is reported to the board, and the statistics are going to show you the difference in that. It also has product or device events, so that is if there's a patient death or serious disability associated with either a contaminated drug or device, or with the use or a function of a device, or associated with an intravascular air embolism. And then the next group is a patient protection event, so that is a minor discharge to a wrong patient, a patient suicide or attempted suicide. And then the next group is a care management event. So again, that's that patient death or serious bodily or serious disability associated with either a medication error, with a hemolytic reaction due to administration of ABO-incompatible blood, related to hypoglycemia, or due to spinal manipulative therapy. And then the next one, in number 5, is a patient death or serious disability associated with electric shock. Any incident in which a line contains a wrong gas or is contaminated. Again, that death or serious disability associated with a burn, associated with a fall, or associated with the use of restraints or bed rails. And then the last two is the criminal event. So this is care ordered or provided by someone impersonating a healthcare provider, the abduction of a patient or sexual assault on a patient, or death or significant injury of a patient or staff member from physical assault. And then the last is kind of a catch-all, and it is an adverse event or series of events that cause the death or serious disability of a patient, personnel, or visitor.
It's important that in the law they also defined what that surgical or serious disability means, and it means a physical or mental impairment that substantially limits one or more of the major life activities of an individual, or the loss of bodily function if the impairment or loss lasts more than 7 days or is present at the time of discharge from an inpatient healthcare facility, or the loss of a body part. And then the other definition that was added in the law, because this was actually a change, was surgical or other invasive procedures are defined as operative procedures in which skin or mucous membranes and connective tissue are incised or an instrument is introduced through a natural body orifice. They include all procedures described by the codes in the surgery section of the CPT. So what happens when the medical board gets one of these adverse events? So the event occurs, it's as listed in the Health and Safety Code section, and it actually requires the board pursuant to that reporting pursuant to 2216.3. So they send in this report to the medical board. So the adverse event, it's received by the board, and it's initially given to the licensing program. So the first thing that they're going to look at is this facility licensed by, it's one of our facilities that is accredited by our accreditation agencies that we oversee. And if it's not, then we'll forward it to either the appropriate accreditation agency, or what could happen as well is that facility might not be actually any of those, and so we would forward it over to enforcement to take appropriate action against that facility. So then what happens after that is we request the accreditation agency to go out and do an inspection. We send it to the accreditation agency, they review that adverse event report, and they determine what the appropriate action is. So then in some, not all cases, but in most cases, they will then go out and do an inspection of that facility. After that inspection, then they actually forward the results to the medical board, and then we're going to be looking at it, okay, did they do the appropriate action? Do we think based on what the activity was, did they take appropriate action? We post that survey or inspection on our website so everybody can see it. And then if necessary, we follow up to make sure if there was a deficiency found, was that corrective action plan, was it addressed, and did we get the outcome report? Then once that happens, then we'll post that information on our website. But then we look at it from that second view too, because in most events that happen in outpatient surgery settings, and this is something that a lot of individuals, we've had discussions over and over again, unless in most instances there was something wrong with the equipment, quite frankly, a brick fell out of the wall on someone, I mean, something like that, usually the event that happens, it's due to the physician, something the physician did. So then we're looking at it to determine, okay, was this physician negligent? And so then we will actually send it to enforcement and open a case to look into the care and treatment that's been provided to that patient. This is something we worked really closely with, actually with the California Ambulatory Surgery Center Surgery Association, because patients were getting these letters, but again, it's kind of like the death certificate project where they didn't file the complaint. This came in through an adverse event report. So we really changed the requirements then to in the letter to explain to the patient that they were getting this letter because we got an adverse event report, that we were looking into it. That's the role of the board. And what we were writing to the patient for was to get that patient authorization for those medical records, because without their authorization, as you all know, then we can't look into those cases unless we have enough for a subpoena. And this wouldn't warrant a search warrant. So that's what we do with all of those cases. So we're going to look and we're going to follow that through the normal enforcement process. The adverse event report itself is actually confidential, but it's the outcome of that report, what I talked about with the corrective action plan when the accreditation agency goes out and does that inspection. That's public. The corrective action plan is public, and any outcome reports, those are all public and get listed on the board's website. And the PDF is right there. It's actually a really great website because you can go out and click and look up on it. So the adverse event report for the physician side, again, as I already discussed, we look at it from a possible violation and we follow it through our normal central complaint unit for processing. So here are the statistics that we actually have. So in 13-14, this was a partial year. So you remember we received 12 when they were reporting to the California Department of Public Health. because they were getting the reports. Now we have 50 in the partial year. We received, about that same number-ish, 104, if you doubled it, 104, 111, and 118. And then again in this year for portion of the year, it was actually not 19, I'm a year behind, it was 18 that it became effective. But anyway, for a portion of that year, we received, because those transfers really is the big number that's going to show here. So we received 165 reports in the last fiscal year. And so just to give you a little bit of a breakdown on those numbers, so 10 surgeries or other invasive procedures performed on the wrong body part we reported. 1, because the surgery or other invasive procedure performed on the wrong patient. 4 were wrong surgeries. 9 were retentions of foreign object. 12 deaths occurred during or up to 24 hours after induction of anesthesia. 80 transfers of a patient to the hospital or emergency center for a period exceeding 24 hours. 45 surgical events were identified as other. And most of those, just to let you know, they were colonoscopy complications or respiratory distress. 1 fell in the category of a patient protection event identified as other. 1 was a care management event. 1 was an environmental event. And with that, we will open it up for any questions.
Thank you, Ms. Kirschmeyer and Ms. Alameda. Do we have any questions? Dr. Hawkins?
So I'm just curious, you have a couple of layers, things get referred to licensing and then also to the medical board. What type of time frame do these cases take to settle? Realize there must be some variation depending on what type of case it is. How long does it take to settle these?
So they would fall, if it's against the physician, it's going to fall into the same criteria. So it's going to be in the central complaint unit. If it gets reviewed there and we close it there after a review, it's about approximately right now, I think in the last annual report, it's about 140 days. If it goes out and requires investigation out in the field, it's going to be 500 days. And then if it warrants disciplinary action, then that adds about another 400 days between the accusation and due process. So it would follow that same category. Now, for them to go out and inspect, I think, Carrie, maybe you can, I don't have the law in front of me, but I think they only have 30 days to go out and inspect, and that's when we follow up with them to make sure. So if it's accreditation agency issued, they have much shorter timeframes for them to go out and inspect the facility. Is that correct, Carrie? It's 30 days, I think.
It's shorter if it's something.
Yeah, if it's urgent, I think it's 5, right? Yeah.
Dr. Yip?
I have a few questions. First, disclosure. I'm a shareholder of Surgery Center, which I did 10 cases a year. So, question number 1, I think this is very good. I hope we have a standing agenda on the enforcement committee meeting every time. And number 2, how many accusations as a result of this information activity review that generated the past 1 or 2 years?
So I cannot answer that right here, but I can definitely get that information and get back to you.
How about manpower? How many staff involved, like quarterly, half-yearly, look at all the statistics, medical consultant review all the cases that particularly result in death? Are we doing those things?
So we have one individual that works not completely full-time on this. We're actually revising this program to where we're going to assign it to one person for a lot more of the enforcement side of it as well, except for if it needs to go to a complaint for the physician side. But we have not quite a full PY in our licensing side that follows up with the accreditation agencies, that makes sure our database is up to date, that make sure that they check with the accreditation agencies to see what they're doing. And then on the enforcement side, it falls into the normal realm of, depending on where the entity is or where the physician is, it goes to all of the analysts that we have there.
Mm-hmm. And the other piece of information I think we can have the agency help is if they can require the surgery center on the discharge paper, at least one page say, the Medical Board of California is responsible for overseeing, and you can contact our board if any question relating to your care at the center or the physician.
So because there's physicians in the facility, that's a great idea. I think that is fantastic. I think we should look at that as maybe a future change or something we can put on. So there's 2 different things here. First of all is that if they have a physician in there, they're going to be required to post the sign, which is soon going to be changed. Either they post the sign or they have to have it on certain documents that's outlined in our regulations. So the patient should be seeing that anyway. but I think that's a good idea to have that.
You may be posing in the doctor's office. I'm not sure they are required to pose in the surgery center.
Well, it should be because it's a physician requirement. It is not a facility requirement.
Yeah, it's their practice location.
Yeah. So along those lines, we've been hearing that individuals aren't aware or, you know, maybe it's been so long since we've done that. So we're actually going to run another article on the posting of that notice. And then we're also going to be tweeting it out and sending it out in a blast to licensees to where they know that. That's a little off topic, but just to let you know. And then the other thing is there is a requirement, though, in the law that they do have to post that this accreditation agency is accredited by whomever the accreditation agency is, and that complaints go there. So then if they got a complaint, they'd have to go through their process and notify us. So, but definitely take it back and make sure that they are posting those signs.
Thank you.
Dr. Granada, did you still have a comment? No, okay. Dr. Kraus?
Thank you. For the record, I will state my conflicts of interest. I have an ownership interest in an ambulatory surgery center. I'm a past member of the board of the California Ambulatory Surgery Association. I think the board has been doing a remarkable job, especially since this was foisted upon the board when the Department of Public Health threw up its hands in frustration and said we will no longer provide oversight. And perhaps you touched on this, but it occurs to me that in some respects this is an unfunded mandate. I think the board still derives all of its operating revenue from physician licensure fees, and perhaps we should speak to legislators and others about potentially having some fee that would be assessed upon ASCs that would support the expenditure that the board has in oversight of ASCs. The other thing that concerns me, and you don't have to respond to each iteratively, I'll tell you what my concerns are, and then you may respond, is that although the intent is to protect the public by requiring that procedures and surgeries that are done under a deep level of anesthesia be done in a safe hospital or ambulatory surgical center setting, I have the impression that there are many procedures done in offices, whether they be medical offices or dental offices, with deep levels of anesthesia without a regulatory body necessarily providing oversight for that. And I don't know that the medical board has any way of knowing about these other than should there be a adverse outcome that gets into the press or should there be a patient complaint. But I think, again, we might consider working with legislators and regulators regarding better defining what may be safely done and may not be safely done in the office setting. I've also mentioned in the past that I think the death certificate project is a worthy endeavor, and I'd like to consider whether or not a death certificate project could be applied to outpatient surgery as well. I know that we require an adverse report to be filed if there is a death within 24 hours. But sometimes the adverse consequence that may lead to death may be a week later or 2 weeks later. So if there were some way of gleaning data from death certificates regarding whether or not there had been recent outpatient surgery, whether it be in a hospital setting or an ASC setting, that would be worthy of investigation. The other frustration I've had is it seems that hospital outpatient departments and ambulatory surgery centers have very different requirements in terms of adverse event reporting. And I think it would be of benefit to the public if we could move towards some kind of equality of reporting, whether it be a hospital setting or a ambulatory surgery setting, so patients could make wise choices in terms of where to have surgery done. But again, thanks for the great work you have been doing.
Absolutely. Just a couple that we can address here. The potential for a fee. So when these accreditation agencies themselves, not the outpatient surgery settings, but the AAs, when they actually renew, they do have to pay us a fee. So there is some funding that comes in from the entities themselves. And it's based upon how many they actually accredit. So we do get limited, some funding that does come in from that. As far as the, the who has oversight over those entities within the hospital setting, I couldn't agree more with you that this is something that is a problem, and you're absolutely right. When we find out about it, and this is something I've even get more involved in as I've been reviewing all of the investigation reports when the investigators went to DCA, is looking at, and we really kind of have to have an expert come back and opine a lot on that to say, okay, did they take this individual to the level that they lost their life-preserving reflexes? Then at that point, if they say yes, then we can say, okay, was it accredited? Because I think it's a very gray area, as you know better than I do, the mix of drugs, what they're doing, and so I don't know if that would be in the future. It's definitely something I think we can talk about as we look at legislation, but that has always been an issue as to what really defines that life-preserving reflex level. Excuse me. And then and that would go in line with defining what was done in the office and not. And yeah, we can look. I'm not sure if there's anything listed on a death certificate that would identify it as being from a surgery, but we can look, and I can talk to CDPH and see if they have anything like that. And then the reporting. So this has been an issue since day one. CMS has requirements. The medical board has requirements, and CDPH has requirements. It's something that we've been trying to meet. Carrie's smiling because she knows how much we've tried to meet with B&P staff and everybody to try to get everything the same. The problem is you're two state entities, right? So you can get it between two state entities, but one of those is a federal entity, which we in California would have no authority over. So there might be a way in the future that we can try to get them more similar, and I think a lot of times we have looked at trying to make them the requirements the same, but it would take changing the law drastically to do that, but it's something that can always be looked into.
Ms. Lubiana, you have?
Yes. Question about the number of adverse event reports. So besides the 2014 legislation, do we have any insight as to the increase of the number of reports over the past 4 years?
Yeah, so let me just get to my slide here with him. So if you look at the slide, the first thing, the 13-14, that was just a partial year because fiscal years go by. So law changes on January 1st. We do data from July 1st to June 30th. So in the first one, the reason it was only 50 was because it was only 6 months of data. And so then the next years, you can see they held pretty much around that number in the hundreds to 118. Then the increase on the 165 on 17-18 was as of January of 2018, again in the partial year. So for 6 months, we received those patient transfers. And that was a change in the law that required them now to report transfers that were over 24 hours to the medical board. And once that changed, that drastically changed the number that we were getting. In fact, if it's 165, it looks like an increase of about 60. There's probably the next year, it'll probably be in the 200s. Yeah.
Thank you for clarifying.
So it's all law changes kind of in timing.
Dr. Bolat?
Yeah, just picking up, can you describe when the law changed? What do you mean by transfers, please?
Yeah, so right now, what the law changed it to include, so this was when we added, due to discussions with our interested parties. I just want to get the exact wording for you, Dr. Bolat.
Thank you.
Oh, thank you. So now it's transfer of a patient to a hospital or emergency center for medical treatment for a period exceeding 24 hours following a procedure. So I go in to have a colonoscopy today, and 24 hours from now I ended up in there, or I end up in the emergency, and I'm there for longer than 24 hours, then you have to report. So you transferred me, yeah.
Okay. And then the other question is, you were talking about the 3 groups, 2 state, 1 federal. And so when you look at the whole population of ambulatory care surgery centers, those that are accredited and those that are not, I don't know what that N is. Probably people from other organizations would know how many that is. How many of those that are accredited are deemed status? So in other words, CMS, the Joint Commission, for example, would have deemed status. So how many of those? Do you
I
have a
don't know
sense
out
of
of that
that?
900. We actually started capturing that because the problem was people were writing back to us, because what happens with some of those entities like Joint Commission, they will send us both those that are accredited, those that have both, and those that don't have accreditation. So they weren't reporting all of the information. Well, in the law, they don't have to report all the information unless they're accredited. So we wanted to identify those so we can actually get that number, because we have either yes or no as to whether they're also CMS certified. So we can get that information and provide it for you.
I would just be curious, because then maybe it is, you've got at least two entities that can work on this information if many of them are deemed. So that was my question. Thank you.
And I'm pretty sure that several of them are both. What we find also is because of the timing of the what it takes to become CMS, and Dr. Crouch, you can probably tell us how long that takes, but in order to become CMS certified, because you have to wait, you have to apply, you have to wait for them to come out and inspect and everything, with the accreditation agencies is quicker. So what entities will go in is they'll go in and apply for accreditation, get the accreditation, go into deemed, and then drop the accreditation and just be CMS certified.
Thank you.
Any additional questions from members? Okay. Thank you, guys. Kamar Gil, did I say that right?
My name is Kamar Gill. I'm from Fresno, California, and I had two questions in regards to this presentation. The first one being, if the enforcement or adverse event reporting and enforcement is any different for hospital-owned facility versus privately physician-owned facility. And number two, the algorithm that was shown to us that, once the adverse event is reported and if the facility is certified by an accredited agency, the whole investigation process is delegated to that particular accreditation agency. My question is, if they were to file a closure report, does medical board have any say to reopen the investigation or handle it internally through CCU or Health Quality Investigation Unit? So those two answers I'll be looking for. Thank you.
Thank you. Are there any additional questions from the audience? Any questions on the phone? Okay, let's move
Susan
to...
Moore, your line's open.
Hi. As you should know by now, I was surgically assaulted, disabled, and disfigured by a board-certified plastic surgeon. I'd been highly referred to by my PCP for medically indicated breast reduction. The surgeon runs a privately owned ambulatory center with no effective oversight. He's the president. His wife is the office manager, only they don't tell people that. I didn't know that they were connected in that way. I came to after the surgery 2 hours later than I was supposed to, according to the schedule he gave me. I was stuffed into a compression garment I couldn't breathe in. I was cut up in ways I had never told about. I was in mind-blowing pain, knew something was terribly wrong. I told the surgeon, who immediately went into deny and defend mode. He had treated my skin and muscles like excess fat and removed deep connective tissues that my body needed, which have rendered me disabled and in excruciating pain. Before this, I was very active, healthy, ran my own businesses, which I loved, and as a result of the assault, I'm in declining health. The pain I described, more than I could possibly ever have imagined. I can't sit, move, or function normally. So this is severe disability, major, lasts more than 7 days, loss of body parts. Now, there was no, he didn't file any kind of adverse event report. Rather, what he did is he fabricated my records. I was probably about a 6 on the Aldrete scale, not even an 8, and they tossed me out of that surgery center 1 hour to the minute after I came to. I know many reasons, including the text I was making to let people know that I had come out of this. I was wheeled in a wheelchair to my friend's car, dumped into it bleeding, sat on a plastic wrap so that I wouldn't bleed all over the car. I was throwing up into a bag. The surgeon wrote no complications. He lied in his records. His photos are misleading. What do you think? A plastic surgeon accused of surgical assault is going to show normal photos? So you can't look at medical records and say this is the thing. This is one major thing we need to change, because for good doctors, they want to get it right, and for doctors that are covering up things, they write these fraudulent notes, and then the person such as myself, who's living a nightmare, has no say in the matter. I was pressured, lied to, coerced to get this procedure. They said I only had 2 months, or Health Net would never again cover the breast reduction. I've talked to hundreds of women since this time because I formed a coalition. This is widespread, and I promise you that. Now, a lot of women don't report anything. They're threatened by the surgeons, or they have gag clauses, or their lawyers, if they're lucky enough to get one, tell them to keep quiet. So these events, all these things you're talking about don't even happen. The Health Technology Advisory Committee said liposuction is an elective pay-out-of-pocket procedure. Data is not collected as to how many procedures performed or the resulting complications. Clear, important statistics on fatalities and complications from privately owned centers may be withheld. They are withheld. And
3 minutes, please conclude.
the thing is that these centers where they're doing innately bad procedures and covering up crimes, I reported to this health board. They did nothing.
Are there any
I have no further comments.
Okay, thank you. Let's move to our next agenda item 19, discussion and possible action and recommendation from the Special Faculty Permit Review Committee. Dr. Bullock.
Thank you, President Pines. On December 7th, 2018, the Special Faculty Permit Review Committee held a teleconference meeting. During the meeting, the committee reviewed and discussed appointing Dr. Fabrizio Luca as Chief of Colorectal Surgery at Loma Linda University School of Medicine. Because Dr. Luca currently holds a special faculty permit, this appointment must be approved by the committee and the board. Please turn to Agenda Item Board 19-1 in your meeting packet for a detailed report on Dr. Luca's qualifications, medical school, and postgraduate training. Dr. Luca's area of expertise is surgery, specifically in the area of robotic rectal cancer surgery. Dr. Luca has assisted in the advancement and development of robotic programs in the specialty of colorectal, esophagogastric, and pediatric surgery. Dr. Luca is currently working on implementing an enhanced recovery after surgery protocol in the Department of Surgery. Dr. Luca possesses excellent surgical skills and is a leader in improving the system of surgical care at Loma Linda. Dr. Luca has taught numerous lessons in the field of surgical oncology and minimally invasive surgery for the general surgery residency program and actively participates in the Objective Structural Clinical Evaluation, or OSCE, for Loma Linda's medical students. Dr. Luca has assisted in launching different specialties in using robotics and different techniques and participates in patient progression meetings. If approved by the board, Dr. Luca will serve as the Chief of Colorectal Surgery at Loma Linda University. Dr. Luca has become a significant and strong member of Loma Linda's Department of Surgery and has led the Division of Colorectal Surgery in the direction of continuous growth. As a result of Dr. Luca's substantial impact to the department, Loma Linda has received recognition for high performance designation for colon cancer surgery. Loma Linda has demonstrated that Dr. Luca has the qualifications and expertise to serve as Chief of Colorectal Surgery at Loma Linda. The committee has reviewed Dr. Luca's qualifications and recommends that the board approve Dr. Luca for the Chief of Colorectal Surgery at Loma Linda. And this concludes my report. And if there are any questions, I please ask. If not, hearing none, I make the following motion. The board approved Dr. Luca for appointment to the Chief of Colorectal Surgery at Loma Linda pursuant to Business and Professions Code Section 2168.1C1. Thank you.
Second. Okay. Second. Yeah, we got a second. Mm-hmm. Are there any comments or questions from the members? Any comments from the public? Come forward.
Yes, thank you. Hannah Reed here for Black Patients Matter. We are so fortunate here in the state of California, so blessed to have such talent wanting to become faculty members, especially at our esteemed Loma Linda University. But in terms of Black Patients Matter, we just want to point out that certainly as far as academia and this doctor's resume, it's outstanding, it's stellar. But I would just point out that we were somewhat concerned that perhaps the patient has no experience in treating African American patients, and worse, maybe is not even interested in learning. So that's probably the only thing we want to point out. Thank you.
Thank you. Any additional comments from the public? Any comments from the phone?
I show no comments.
Okay. Ms. Cruz-Jones, can we get a roll call?
Dr. Bolat?
Yes.
Ms. Friedman?
Yes.
Dr. Gonadev? Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Ms. Lubiano?
Yes.
Dr. Lewis?
Aye.
Mr. Wormuth?
Aye.
Ms. Wright? Dr. Yip?
Aye.
Ms. Pines?
Aye. Let's move to our next agenda item 20, update, discussion, and possible action and recommendations from the Midwifery Advisory Council meeting. Ms. Holzer.
Good morning.
Good morning.
Diane Holzer, the Chair of the Midwifery Advisory Council. Our requested action is disapproval of the following agenda items for our next MAC meeting. Discussion on establishing goals for 2019 for the MAC. Update on midwifery-related legislation. Selection of new members to the MAC. We have 1 midwife position, 1 physician position, and 2 public positions open. Selection of a new vice chair. Discussion and possible adoption of an administrative procedures manual. The following item listed here, presentation on protected peer review, we will not be discussing, as the person who put that on the agenda has requested to withdraw it. She won't be giving us that discussion. Selection of 2019 MAC meeting dates, report from the MAC chair, an update on the program, on the midwifery program, and discussion on actions to improve services for midwifery clients from physicians. Unfortunately, our last meeting we did not have a quorum, so there were no actions taken, but we were just provided with information on the board's enforcement process and updates on the programs and the licensing reports, and a presentation of the to-come administrative manual that has been developed by staff, and an update on our term limit requirements, and we tabled the election of the vice chair until our next meeting.
Okay, thank you. Can I get a motion? Okay, second? Okay. Are there any comments from the members? Dr. Hawkins?
Just a brief question. Do you know why you didn't have a quorum last time? Do you expect that to be a problem going forward?
We don't expect it to be a problem going forward, no.
So unfortunately what happened, it was the day that, I can't remember, there was something that happened at the LAX airport, and so unfortunately one of our members was not able to get on the plane to get there.
And the runway was very slippery. And then, of course, our dear public member, Barbara Yaroslavsky, was.
Oh, right. Yeah. Okay. Are there any comments from the public? Any comments on the phone?
Any comments on the phone? Hello?
Sorry, no comments.
Thank you.
Did she say no? Okay. Ms. Cruz-Jones, can we get a roll call?
Dr. Bolat?
Yes.
Ms. Friedman?
Yes.
Dr. Gonadev? Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson? Ms. Lubiano?
Yes.
Dr. Lewis?
Aye.
Mr. Wormuth?
Aye.
Ms. Wright? Dr. Yip?
Aye.
Ms. Pines?
Aye. Moving on to agenda item 21, discussion and possible action to amend Title 16, California Code of Regulations, Section 1321, regarding postgraduate training. Ms. Webb and Ms. Alameda.
Members, I am pleased to say that we have gotten word that legislation is going to be offered to clarify that the board will be approving the postgraduate training for combined programs in dental and medical for the oral and maxillofacial surgery residency programs. And so that is a much quicker way to make sure this is addressed. And so this was brought forward to add that to a rulemaking that the board has already approved. So this item is not necessary at this time.
So we don't.
It's much quicker in light of the new review process going through DCA and agency to do legislation than to do it through regs.
Okay. So no questions? Okay.
Just a question, Ms. Webb, is that my conflict is that Loma Linda oral surgery residents rotate through my department, so I do know, and they are MD DDS, so they have both degrees, so that's why I want to make sure that they because they fall under our training because they have an MD degree along with the DDS, so I just want to make sure that they are not affected with some requirements which they can't meet. Thank you.
Yeah, thank you. Okay, moving on to agenda item 22, update from the Enforcement Committee. Dr. Yip.
Thank you. Yesterday we met the Enforcement Committee meeting, and Ms. Delp gave an enforcement update that include information about the enforcement statistics and enforcement timelines and highlights concerning the various programs within the enforcement, such as the organization of urine collection training for complaint investigation unit and probation unit staff, establishment of processes to implement SB 1448, and information about the transition from the vertical enforcement model to joint investigation conducted by the board, the Health Quality Investigation Unit, and the Attorney General's Office. Mr. Chris and Ms. Nichols gave a presentation about the current workload and vacancy rate in the Health Quality Investigation Unit, and finally the meeting ended with informative presentation given by Ms. Moore, our staff from the Discipline Coordination Unit, Ms. Alvarez and Ms. Westford from the AG Office. They explained the board's disciplinary process regarding the filing of accusation. The PowerPoint can still be viewed from the meeting material yesterday. And this concludes the Enforcement Committee update. For the board member who are not there, and also for the new board member, I encourage you to read the minutes from January 2018 Enforcement Committee meeting. There are a lot of material there. It's like an instruction book. It's very informative. So.
Thank you, Dr. Yip. Are there any questions or comments from the members? Any comments from the audience? Any comments on the phone?
No comments from the phone.
Okay. Let's move to our next agenda item 23, update from the Attorney General's Office. Ms. Castro.
Good morning.
Good morning.
So for the benefit of our two new board members, I'm Gloria Castro. I lead the staff members at the Attorney General's Office and the Health Quality Enforcement Section, which was created in 1990 by statute to serve this board. And that's a unique situation. No other DCA client has a dedicated law firm at the Attorney General's Office. I have the unique honor and privilege to lead the 62 legal staff members at the Attorney General's Office who do this important work on a daily basis, weekends after 5, too much sacrifice. I have 9 supervising deputy attorney generals, 9 paralegals, and 42 deputy attorney generals who come from a varied amount of deep legal experience, many of them former criminal prosecutors, former medical malpractice attorneys, and other folks who are just very committed to public service. We normally hire folks who have 10 plus years of experience due to the fact that this is a very complex area of law, and many of our lawyers are failed doctors, so they actually have a lot of interest in the science that goes into the decision making that these doctors do on a daily basis on behalf of California consumers and patients. So that's who I am. And it's a pleasure to meet you, and you're going to have a great time on this board. It's very important work. The health quality enforcement staff has been busy moving to a different level of service to this board's cases, and we are adjusting to not directing your investigations. We're moving from having handled about 1,800 of your investigations to about 50 statewide. For more details on our legal work, I second Dr. Yip's commentary that you should really please read the last year's Enforcement Committee meeting minutes from January 18, 2018. There was a good little presentation there on how your investigations are managed. And even though the vertical enforcement program has been repealed, it still explains all the different steps. At the same time, for more details on our legal work, Supervising Deputy Attorney General Alexandra Alvarez and former lead prosecutor Carolyn Westfall, both former prosecutors, they presented and gave comments yesterday along with Ms. Valerie Moore of the Central Complaint Unit. The enforcement meeting specifically covered the management of your accusations, which are the vehicle which places the public on notice that the doctors are under review by their licensing agency. And we love flowcharts and HQE, and I think it's just very important that you also look at this flowchart. If you have any questions on why it takes so long, this is what due process looks like. This is how the licensing management happens when licensees are under your close scrutiny and review. At the same time, we're working to absorb the $1.9 million budget cut and assessing all factors that go along with budget cuts. We continue to correspond and meet frequently with the Medical Board, the Health Quality Investigation Unit, the Department of Consumer Affairs, and the Legislature to discuss this major change to your program and the associated adjustments to the client's expectations of our work delivery to you. We are also preparing for probation notification pursuant to Senate Bill 1448, brought forth by Jerry Hill, as well as the more lenient expert report exchanges that were recently legislated under Business and Professions Code Section 2334. The Attorney General published its second annual report pursuant to Business and Professions Code Section 312.2. This is a report that is legislated, and it concerns accusations that are handled by the Attorney General's office for all 36 Department of Consumer Affairs client entities. So this is all the way from an automotive repair to physicians and surgeons. The report can be found at our website at www.oag.ca.gov. So all clients are listed in this report, including the Medical Board's 2018 statistics with the numbers of withdrawals of accusations, reviews returns, review rejects, and averages and medians for several metrics, including the most important one, in our opinion, which is presenting accusations for public review. And it also includes cases that are resubmitted after initial rejection if the evidence does not meet the requisite burden, which is what was discussed at yesterday's presentation. The final thing on my report is that we've said goodbye to Deputy Attorney General Richard Marino. He retired after many years of public service at the conclusion of September. And we're also sad to see our esteemed Deputy Attorney General Cindy Lopez go. She developed quite an expertise in sex abuse cases and brought a special passion and humor and character and compassion to all of her cases. So we're going to miss both of them very, very much. And this is an expected, ebb and flow of staff. So when folks like that leave, they take decades of experience with them. Mm-hmm. So we look forward to squeezing out as much as possible from Ms. Lopez until April 30th, which is her last day. And that concludes my report.
Okay.
Thank you.
Thank you, Ms. Castro. Thank you for also reminding us about the team that you work with. Sometimes we forget about the power behind the woman. Are there any questions?
Nothing could be done without the staff. I consider it an honor and privilege to get to work with such fine individuals.
Good. Dr. Yip?
Thanks, Gloria. We have worked together for so many years, and one of the most committed civil servants I've ever worked with. Thank you. Question, I think it would be great if legally, technically, we can do it like your package from Amazon or UPS can track the case. with our staff, your staff, is there a way legally, technically, we can do that for the public? That this accusation, which state are we at, collecting evidence, hearing, and anything that timeline that can be legally, logistically published or tracked in online, so that for the family, for the physician involved, they can look at that.
We'd be happy to work with the Health Quality Investigation Unit on their markers as well as ours. Ours are pretty public. I think it would not be a challenge to do. It would just potentially take away from our focus of doing the legal work. So we would need money for that because we'd have to bill in order to compile those statistics. However, given the fact that the legislature already is forcing us to report under Business and Professions Code Section 312.2 and provide numbers as well as metrics, I don't think that the challenge would be too great. Of course, when I get back to the office, an associate governmental program analyst is going to probably yell at me and say, why'd you say that? But I think if there's interest in it and you're going to look at the report and make meaningful changes and take into account all the steps which are on that flow chart, we would be willing to put in that extra effort and energy.
Thank you.
Thank you,
Dr.
Dr.
Granado?
Thank you, Ms. Castro. I know your budget cuts. We still would like to come to an agreement on the VE. That we need some help on VE, not the entire thing. So we need to still work with our staff and really get there somehow or other. But my question is, with the street opioids growing like crazy, especially fentanyl, are you, as the Chief Law Enforcement Officer for the state of California, is AG's office involved with the DEA and the federal government at all in trying to see how we can control that coming through? That really worries me, because at least the prescription opioids, you know what the dose is. You know exactly what you're getting. You might take them too many. But with the street, you do not know what exactly the dose is. It can be 10 times morphine or 100 times morphine. So I'm just curious what's going on at your main office level with this epidemic, what's happening.
So as to the former comment, we have about 50 vertical enforcement investigations that are jointly assigned between deputy attorney generals and investigators right now. So we used to do 1,800, now we're doing 50, and I think we'll continue to work on that process on an informal basis to continue to be responsive to anything that the client identifies as meriting early direction and legal advice. As to the second point, many years ago, when Kamala Harris first became our Attorney General, our Bureau of Narcotic Enforcement was deleted, basically, from the Attorney General's program. This was a major, major change to law enforcement. I know that our Attorney General, Javier Becerra, is very, very committed to the opioid scourge, both legal and illegal, and specifically fentanyl, which exposes law enforcement to having to wear hazmat suits before entering. We all know that a microgram of that could be lethal, and no one knows what's in it. So I will certainly share your comments, Dr. Ganadev, with our AG, who is very committed not only to this board, but to all of the Department of Consumer Affairs client entities and to public protection and law enforcement.
Thank you. Dr. Lewis?
Well, that's great, for California. I applaud that. But the one word that sticks out when I watch the news the last couple of days is China. And the federal government are the people that can deal, hopefully, most effectively with what's passing into our border. So you can do what you want in California, which is great, needs to be done. But until you partner with the federal government and federal government puts pressure on China and those other countries, we're going to still have those drugs coming in and killing our citizens and the country. So, that's the source of the fentanyl now. So, okay, thank you.
Thank you. Thanks. Before you leave, Ms. Castro, I just want you to take back from, especially from staff and from the members, to Ms. Lopez. She will be greatly missed. She's one Carrie and I talk about all the time, because if we were going to go to hearings, she is the one. She has been a great litigator for this board, and she's taken a lot of our hardest cases, and she's really kind of herself identified the appropriate way to to prosecute some of our sexual misconduct cases. And so just please tell her thank you on behalf of this board.
And Kim, I really appreciate that you took the time to say something so public about her. I know she will be very thrilled and touched, and if she's watching right now, she's probably crying. So, thank you.
Thank you. Hannah Reed?
Yes, hello, thank you. So we at Black Patients Matter are deeply concerned at the lack of racial diversity within the Attorney General's office, specifically targeting African American physicians, which serve to discriminate against Black patients, as studies are emerging showing Black patients doing better health-wise when being cared for by African American physicians. Steps need to be taken to close the racial disparity. The first step would be in the hiring of more African American workers, including Black lawyers within the AG office. In our federal civil rights lawsuit against folks in the AG office, in the California AG office, along with other underrepresented minority physicians, will continue to increase until changes are made and things are addressed. If in fact we're in the business of improving patient health, especially closing the health disparity, especially closing the gap in health disparities in underrepresented minority groups, then in fact we need to be accountable to those actions and start hiring Black workers, including African American lawyers and that sort of thing. So thank you very much.
Thank you. Kamar Guru Giyu.
My name is Kamar Gill, and I'm going to speak briefly on what Dr. Gananadev has raised, what is state doing. And she's made it very clearly that the junior senator is pretty much not doing anything since her initiation in 2011 onwards. What I want to tell the folks here in public is California is one of the very few states who has not sued Purdue Pharmaceutical, which has produced OxyContin. Although there are 30 plus individual counties who have filed cases, but state of California has taken a position that it's not going to sue the people who have manufactured this drug and marketed it to physicians and general public and created a crisis. In fact, recently there was a news item saying that they were looking into designing some addiction treatment of something that they have created in first place. So that's something that I would want the Office of Attorney General's deputy here to take back as a message. Secondly, the vertical enforcement program, if you look at closely how it started in 2006 and how it culminated in 2018 and how it was not renewed, vertical enforcement program was started as a vertical prosecution program. That was the exact word which was used when it was started. And it has been a program during the tenure of Jerry Brown as an AG from 2006 to 2010, and then Kamala Harris for about 8 years, allowed the Attorney General's office to usurp the authority of the medical board, the autonomy that the statutes provide to the medical board, and essentially criminally prosecute physicians aided and abetted by the senior DAGs. I have name of all of them here, but in interest of time, I won't read all of them. But essentially what was done from 2006 to 2018 was an intent of a political agenda that was forced upon physicians. And in last almost 12 or 14 years, that's what we've seen. And I'm happy it's all over, because now medical board can actually focus on consumer protection versus furtherance of a political agenda. Thank you.
Thank you. Other, go for it.
morning. I'm Bridget Grammy from the Center for Public Interest Law. And for the new board members who don't know about our center, we are an academic center at the University of San Diego School of Law, and we monitor all of California's licensing boards, including the medical board, for a long time on behalf of public protection. So I just want to say quickly with respect to the last comment and with respect to Ms. Castro's comment about vertical enforcement, I'm glad to hear that you are still willing to work and that Ms. Castro is working with you, because we do think this is a very important public protection mechanism, and we don't think it's serving anybody to just get rid of it. So I do want to encourage everyone to continue doing that. Thank you.
Thank you. Are there any other comments from the, come forward?
I show no comments.
At the last meeting, I asked Ms. Castro to give us an update on that issue that Judge Feinstein brought up at a meeting in January of 2017 about the Attorney General's office. A DAG had screwed up on something and a case had to be thrown out. And I guess we still didn't get that report today. I don't know if any of you ever just go to Breeze, probably not Breeze because it's hard to use, but maybe to our website and just look through cases and see some of the interesting cases that are taking place and how long they take to happen. If you go to our website, I actually have a personal button on it for myself called Hall of Fame, and it's all my favorite cases. And I printed out some today that I just wanted to go through real quick that I'll do until my time runs out. The case of Frank Fisher, he had an accusation filed in 1999 and wasn't placed on probation until 2005. He then went on to get another accusation in 2016 for unprofessional conduct, gross negligence, repeated acts of negligence, and incompetence, and got another decision in 2017. But it took from 1999 to 2005 on the first one. Dr. Ronald Groost, even though he was convicted in December of 2017, no accusation was filed until later that year. The work was already done for the medical board, and you just sat on it for a year and didn't do anything. Dr. Richard Kim got a felony conviction in 2016 for pointing a gun at his wife and nanny. He was actually got a felony conviction in 2016, and you guys didn't file an accusation until December of 2018, and he's allowed to practice all that time. Dr. Emmanuel Mofu has a DUI arrest in August of 97, September of 97, DUI arrest in January of 2001, DUI arrest in February of 2014, DUI arrest in November of 2015, convicted of speeding on the highway in January of 2016, convicted of no evidence of registration in May of 2016. So the first charge was in 1997, but nothing happened until 2016. This doctor was accused of beating his wife in 2017, and he got a public reprimand. This doctor got his accusation dismissed. He surrendered his license in Arizona and Texas. You guys filed an accusation and then dismissed the accusation in 2015. He still shows as current on Breeze, but he actually died in 2017. And my time's up, but I have a whole bunch more like that. Check out the Hall of Fame button on our website.
Thank you. Are there any other comments from the audience? Any comments on the phone?
There are no comments at this time.
Okay. Moving on to agenda item 24, update from the Department of Consumer Affairs, Mr. Lay.
Good morning. President Pines, Vice President Lewis, Executive Officer Kirkmeyer, members of the board. It is good to see you all again in beautiful Milpitas. Thank you, as always, for giving an opportunity for the department to provide an update to your board. For the purposes of the minutes and for the record, my name is Patrick Clay. I'm the Assistant Deputy Director for Board and Bureau Services at the Department of Consumer Affairs. And before I start, I wanted to take a point of personal privilege to extend a warm welcome to your two newest board members, Ms. Friedman, Ms. Lubiano. Welcome to the DCA family. Welcome to the party. We are incredibly excited to have you on board. For your benefit, our office supports all DCA boards, DCA board members, and staff in any areas that you may need, whether it is budget and finance information, communications and public affairs, human resource. And we're also your official liaison to the Business Consumer Services and Housing Agency and the Governor's Office. So anything that you need, even if it's pizza delivered to your door, we would be happy to support as you're onboarding as a new board member or throughout your tenure as a board member. With that, I thought I'd start this update by providing some highlights from 2018 from our boards and share a few numbers and figures. This past year, our office hosted 9 licensing and enforcement work groups, which, if you recall, were work group sessions that convene staff from across all DCA boards to share best practices in the areas of licensing and enforcement. We also hosted 4 directors' quarterly meetings, which were opportunities for board executive officers to connect directly with the DCA executive team. And we also hosted 2 directors' teleconference leadership calls, which were opportunities for board presidents and vice presidents to connect directly with DCA Director Dean Grafilo and members of the senior staff. We hope that these activities were good opportunities to promote open dialogues and further our collaborative mission to protect California consumers. But we're always looking for feedback, so if you have any suggestions about what you'd like to see for 2019, please feel absolutely free to communicate those suggestions directly to us. Since I'm talking about 2018 in review, I also want to let you know that the 2018 DCA annual report is now available online. That report provides a much more comprehensive review of DCA activities for 2018, a full accounting of achievements for all 38 DCA boards, bureaus, and commissions that make up the DCA family. So if you have some time, invite you to review that report, whether you're a board member or a member of the audience. Report available online at www.dca.ca.gov. My next update is regarding a transition to a new administration. And as you know, on January 7th marked a historic new era for our state as Governor Gavin Newsom was sworn in as the 40th governor for the great state of California. We at DCA are incredibly honored and excited to be part of this new team. Our department is looking forward to do everything that we can to further the governor's vision. The department has met with the transition team, and many new and familiar faces have been appointed to new positions within the governor's office. As for current gubernatorial appointees, the current message is that there is no action on your part needed. There is nothing that you need to do other than continue the great work and service that you've been doing. We intend to maintain close communications with the governor's office and the new team that the governor has assembled, and we will be in touch with them in terms of appointment vacancies and pending reappointments that are coming up in the near future. Related to the new administration, I also wanted to touch briefly upon the governor's 2019-2020 budget. And as you know, on January 10th, the governor's released his proposed budget, which outlined his fiscal priorities for the year. The budget is based on the driving idea of a California for all, and it proposes to pay down debts and pension obligations. It continues to build on strong budget reserves, and it makes some significant investments in the areas of healthcare, childcare, preschool, and higher education. And it also proposes to make some significant changes in the way that the state would purchase prescription drugs. On the day that the budget was released, DCA held a teleconference call with board leadership and executive officers to review proposals within the budget that impacts the department. And yesterday, our budget team, Mr. Taylor Schick, and Executive Officer Kirkmeyer discussed some of the details that were included in the governor's budget. But our fiscal team will continue to follow up with each program individually to help answer any specific questions regarding the budget in greater detail. My next update is regarding Assembly Bill 2138, which, as you recall, is the bill that relates to a board's ability to deny a license based on past criminal convictions. Because AB 2138 affects nearly every board and bureau within the department, DCA has taken steps to support our programs to achieve a successful implementation. We provided every program with a draft timeline to help stay on track for the July 2020 implementation date. The important note here is that in order to stay on track, action will be required by all board by May of 2019. Our department has been working closely with every board to create potential model regulations that could be adopted by all DCA boards and bureaus if they're interested in doing so, in the hopes of creating uniformity across the board and help save some time throughout the regulatory process. Where feasible, DCA will also take the lead on collecting data for the reporting requirements that are included in the bill and complete one report to the state legislature. My next update is regarding the Substance Abuse Coordination Committee, which you recall we're a committee made up of all the healing arts executive officers to examine the way boards deal with substance abusers who are licensees. So this past year, our office hosted 3 substance abuse coordination committees to specifically look at the drug testing standards for licensees who are on probation or on diversion due to a substance abuse problem. And so I wanted to note that this committee voted to make 2 technical changes to Uniform Standard Number 4, which guides all the drug testing standards. The first change is adding language which allows a board to approve alternative drug testing locations and alternative testing frequencies for a licensee who is going on vacation or taking a leave of absence. And that change was added to ensure that a board can still perform drug testing for a licensee who is traveling abroad while considering varying types and availability of testing laboratories around the world. The second change is a policy addition that allows the healing art boards to lower the drug testing frequency to not less than 24 times per year. And if you recall, the current standard is in between 52 to 104 tests per year. So that change would allow a board to lower that testing frequency to 24 times per year, but only if the licensee receives a minimum of 50% supervision in the workplace. And this change was added to reduce the testing costs for licensees who are already under supervised monitoring at their place of employment. And the last thing about this Substance Abuse Coordination Committee, the committee also determined that several other standards may need review. So to that end, DCA will be conducting additional meetings throughout 2019 to examine and potentially change other standards beyond drug testing protocols. And we'll make sure to keep you appraised of any changes that are happening on that front. My next update is regarding the Executive Officer Salary Study. And as many of you know, the department has retained KH Consulting to conduct the Executive Officer Salary Study. The project is expected to take approximately 6 months with an estimated completion time of March of 2019. At this time, our consultants have conducted an initial review with our executive officers to identify themes and challenges and explore expected outcomes for the study and identify perceived challenges. In December, KH Consulting sent a comprehensive survey to executive officers so they may conduct a thorough analysis and comparison of positions across boards and comparable entities. And once again, we hope to have a final products that boards may be able to review in March of 2019. And as my last update, not as exciting, I will close out with some friendly administrative reminders. The first one regarding board member orientation training, or BMOT, very applicable to our new board members. As you know, board members are required to complete this training within 1 year of appointment or reappointment to a board. This one-day training is in the most beautiful city in the world, Sacramento, which details the important functions and responsibilities of board members. You are able to sign up online, but feel free to connect with your executive officer if you need assistance with signing up. The second reminder is to file your annual statement of economic interest, also known as Form 700. It is required by the Fair Political Practice Commission to report potential conflict of interest. The filing deadline is April 2nd, 2019, and can be conducted online. You are required to file even if you do not have any reportable interest. And my final note is that 2019 is a mandatory sexual harassment prevention training year for the Department of Consumer Affairs, which means that all DCA employees and board members are required to take this training, even if it was taken last year. The training is online, interactive, and can be completed at our convenience. Here at DCA, we want to make sure that we do everything that we can to promote a safe workplace environment for all employees. So this concludes my update. Again, thank you so much for having me, and I can take any questions that the board may have.
Thank you, Mr. Lay. I have one question. So yesterday, there was a union rep who spoke and asked about reclassification of our investigators, and I thought this was pending with DCA. Can you speak to that today? And if not, can you provide
Absolutely. Not able to speak about the details about this, but more than happy to take this question back to our human resource team and check the status.
Okay, thank you.
And, yeah, go ahead. Okay. And, so are those investigators a bargaining unit, or they consider managerial? Because a lot of that has to do
on that one.
So it's actually the inspectors. So it's the individuals that we have in our office that do the probation monitoring. And yeah, they're obviously part of the,
They're part of the union, so you have to deal with that too.
Right.
Yeah. Okay, thank you.
Dr. Gananadev?
Thank you, Mr. Lay. On the executive director salaries, I started this as when I was a vice president for 2 years, president for 2 years. Now I'm the past president. And it still hasn't been resolved. So I'm just curious, is that 6 months timeline is actually true?
Yeah, we're definitely on track. And as you remember, part of the issue is there was a prior salary study that was done in 2011. And part of the issue is that salary increases are subject to several layers of review that are some within the control of the department, others are not. That review goes through agency, the governor's office, and part of the challenge is that many of these salary requests, increase requests, are oftentimes denied. And part of what the salary study wants to do is really examine all the factors that are taken into consideration when a salary increase is reviewed. So part of it is examining the complexities of the job duties of an executive officer, and part of that we want to show that over the years the job got incredibly complex, and we want to be able to reflect that. The salary study will also look at what is being done in other states, other positions that are comparable to executive officers. We're also looking at gender parity and looking at gender differences across EOs at DCA. And the goal is that the final product will be a tool that boards will be able to use to really bolster their justification when submitting a salary increase request.
Yeah, one other point I do want to make sure that they look at is that we are the largest board in the entire country. 1 out of 6 doctors in the country has California license. So you have to really compare apples to apples. Otherwise, you will come back with the same solution, same thing what I was told for 4 years in a row. It's so frustrating when it is our money. It's not general fund money. This board approved, and it still ends up going nowhere. Anyway, that's the frustration level. You can see how far it can go. But let me ask you a question actually is, I hear 7th year, I think I'm on the board, multiple patient advocates complain that they are never interviewed by investigators. Is there a reason why the HQIU people can't interview the patient or patient's family when they make complaint? I'm just curious.
Not entirely familiar with the process, but happy to take back that feedback to the HQIU team.
Thank you. Oh, Ms. Bola?
Thank you very much. Got a quick question. You mentioned the change to the uniform standards, and so I'll have to ask both you and Ms. Webb. So was that made by DCA? Was that made by something that we brought forward? The reason I bring that up is decreasing urine toxicology screening for patients that have addictions, regardless of the cost. The standard of taking and looking at how someone is performing or not performing or has a substance in their body is the urine test. So I'd just like to understand that a little better.
Sure, absolutely. So I can break down my answer into 2 parts. The first part is how the committee is made up. So it was statutorily created by Senate Bill 1441. And so the committee is made up of all the Healing Arts Board's executive officers. And very much to this board, they're subject to the Bagley-Keene Act. EOs have voting power, and so collectively they make the decisions. So back in 2011, that committee created the 16 uniform standards, and uniform standard number 4 was the one created by that committee related to drug testing standard. Relating to the testing frequency, as I mentioned, the current testing frequency is 52 to 104 times for the first year for a licensee in a diversion or probation program. Part of the drug testing is really up to the board and the staff that administers the program. It can be a urine test, but it also can be a PET test, a blood test, it can be saliva, it can be hair. Each of the tests have different costs associated with them, have different pros and cons, different legal standing in court. So boards have the ability to use different types of tests at different frequencies. Part of the challenge that was identified is that depending on which board you are, because every board has a different cost structure, the licensee on probation or diversion has to bear the cost of testing. And so when you take into account 52 to 104, a urine test can be $50 a pop. It can get really expensive. And many of the experts that testified during the committee mentioned that although the number of tests is important, another important factor is the randomicity of tests. And so the committee was trying to balance these two factors, having a strong number of tests with balancing randomicity. And so the change that was made is only an exemption. So the testing standard is still 52 to 104, but it's to the discretion of the board to lower it to 24, but that's only if that licensee is under supervision at the workplace.
I see. Okay, thank you for clarifying that, because that was very important. Thank you.
Are there any other questions from the members? Okay, Hannah Ree.
So we here at Black Patients Matter have some serious concerns. The California Business and Practice Code states the boards, bureaus, and commissions in the department are established for the purpose of ensuring that private businesses and professions engage in activities which have potential impact on public health, et cetera, et cetera. And so in our federal civil rights lawsuit recently filed against the DCA, we believe that the DCA is misusing their powers by targeting underrepresented minority physicians which care for underrepresented minority patients, therefore marginalizing and discriminating against Black patients. And so to that end, when DCA leadership the DCA leadership is non-diversified. And when it is non-diversified, it becomes evident why minorities are unfairly targeted in the investigative process. Sadly, the DCA DOI, which investigates the medical board complaints, never acknowledges the few Black workers diligently working long hours despite hardships, as all their DOI stars, staff appreciation and recognition are not racially diverse. While forcing DCA DOI employees to share a break room or use the same restroom or even drink from the same water fountain with more African American co-workers may be disruptive to their workflow, it is this work culture which allows the DCA DOI to successfully investigate and create bias accusation against minority physicians. On June 11, 2019, African-American patient Samuel Bardwell collapsed and was transported by ambulance to El Camino Hospital ER and was subsequently treated by Beth Geekstra, MD. Sadly, Mr. Bardwell was mocked, ridiculed, and cursed at by the physician. Dr. Geekstra was subsequently suspended for abusive comments of Mr. Bardwell. Black Patients Matter supporters filed numerous complaints to the DCA on behalf of Mr. Bardwell with no results thus far. Most recently, Black Patients Matter filed via United States Postal Service registered mail. We are now awaiting follow-up with that complaint. We are deeply concerned that complaints involving Black patients are marginalized by a biased DCA in comparison to prioritized patients. Thank you.
Thank you. Are there any additional questions from the, please come forward.
Along the lines of the sexual harassment class that everyone is going to have to take, it seems this board also needs some training in the importance of sexual misconduct cases coming into the board in the form of complaints. For instance, I think it was last year or the year before, there was the case all over the TV news about Dr. Michael Popkin, who was convicted of sexually assaulting multiple patients. And we know the board knew about this before it even came out on the news and didn't really do anything about it. If you look him up on Breeze today, his page shows no convictions. But if you go to our page, it shows all of his convictions. Isn't it in the law that the medical board is supposed to list all convictions? It's not showing up on Breeze, and this is a sexual offender. We also know the board is investigating a complaint against a doctor who grossly sexually assaulted multiple patients, but there's been no suspension filed. We've not seen anything about him, so he's probably still practicing. Aren't sexual misconduct cases supposed to be a priority, and shouldn't you be warning the public about this doctor? We haven't seen anything, and we know you're investigating this case. So I think you guys aren't taking sexual misconduct cases very seriously, and I think something needs to be done about that.
Thank you. Are there any other? Oh, please come forward.
My name is Kamar Gill. I'm from Fresno, California, and I'm going to speak on a matter that is closed. Ms. Webb, can I go ahead on a closed complaint?
This is a DCA update, so it needs to be related to the agenda
Conduct
item.
of the DCA in the complaint itself, which was referred
Right.
to.
I'm just saying you can speak if it's related to the agenda item, the DCA
Perfect.
update.
Thank you. So I'm going to speak on a complaint number. Control number is 800-2015-012-300. So I'll repeat, 800-2015-012-300. It was referred to Health Quality Investigation Unit, San Jose. Roughly around March of 2015, involved a couple of Stanford and UCSF trained physicians indulging in a practice of medicine which has historically been treated as below the standard of care. In this particular investigation, which lasted from March of 2015 to October of 2018, investigator was changed at least once. Initial investigator who was assigned to the case was Todd Ariyama. He did a lot of undercover work in gathering all the evidence. My last conversation with him was that he got evidence beyond reasonable doubt, which is sufficient for a criminal conviction, and not just the convincing, the convincing evidence. But what happened at the time, Todd expressed his helplessness because on the direction of the attorney assigned to the vertical prosecution model, the investigation file was transferred to an investigator by name of Rebecca Sarnett. And after that, in last about year and a half, what seems to be a big investigation was turned to a case closure. One day after I checked on the status of it, I was under the impression that somebody would reach out for an interview in 3.5 years because I was the one who was the complainant. But that purely reflects that DCA investigators do not reach to patients who complain. So if a physician who's filed a complaint did not hear for an interview 3.5, 4 years, what do you expect a patient would be doing when they complain here in this forum saying that they have not been interviewed or investigated, being called by the investigator? And secondly, if the matter has to be decided, or the direction or the supervision has to be given by the attorney assigned to the case, then what is the role of the Medical Practice Act? So if the political agendas have to be furthered through this process, then it defeats the purpose of having an autonomous body looking at the consumer protection. Thank you.
Thank you. Are there any additional comments in the audience? Any comments on the phone?
Any comments on the phone?
Sure, no comments.
Okay, our final agenda item 25, future agenda items. Do any of the members have future? Dr. Hawkins?
So I'd like to request that we have a presentation on a particular subject. New HIV infections is on the decline in certain high-risk individuals, but it's not universal. Some groups are still experiencing increased incidence of HIV infection and thus risk for AIDS. Pre-exposure prophylaxis, also called PrEP, is a powerful tool to reduce HIV infection and those at high risk. Earlier this month, the board disseminated a document. CDPH encouraged the use of PrEP to prevent the spread of HIV. So I'd like for us to consider sometime this year to have a speaker, have a list once we give an extra talk about the utilization of PrEP to prevent new HIV infection in high-risk groups.
Okay. Dr. Bullock?
Yes, and I follow up from yesterday when Ms. Kirchmeier had mentioned the buprenorphine, which is really, let me back up, it's an X waiver, and the majority of the medication is by a couple of pharmaceutical companies. And I'd like to look at the X waiver in general and to see how, if at the state level, there's another approach to this so that we don't have, we have a big epidemic and we have a very small number of people that can prescribe that drug. And putting that, it's not necessarily a barrier, but every medication we prescribe, be it losartan, Coumadin, or other drugs that are as dangerous, is there something that we can look at to decrease the barrier?
Dr. Gnanadev?
Ms. Pines, actually I was going to ask for an item to be on the board next time, but the president and vice president has a meeting with the interested parties. I would like to wait beyond that.
Okay, thank you. Mr. Woolmer?
First, I wanted to make a comment and basically, let's see. This is strictly my point of view and not as a spokesperson for the board or any other member. But I truly value the public comments that we receive. I think they're very helpful. You may have noticed that I'm sometimes tapping away at my cell phone while you're speaking. I'm not playing Angry Birds. I am, more than likely, I'm making a note to follow up on something that you have said. I think it is very important. We do learn a great deal from what you're saying. That being said, when those comments come with ad hominem attacks, such as that one that occurred against Dr. Gnanadev yesterday, or have occurred against our staff members, I'm pretty good at separating the wheat and the chaff, but to be honest, I question whether or not you are doing what you say you're doing, which is to try and improve this board and our activities, or whether you're seeking revenge for something that seems to have, that has occurred in the past that may or may not, or could very well be an instance where this board has failed you. I would, so that being
leading
said.
to an agenda item?
Yes. That being said, I would like to suggest that I'm not looking for regulations on what you say to us, but what I would like is to have the staff develop a best practices type of document on how to most effectively testify to the board.
Okay. All right. Do any other board members have anything additional to add to future agenda items? Okay. The meeting is adjourned. Oh. Dang. No, I'm kidding. Please come forward.
So it sounds like then, Mr. Wormuth, you're asking for public censorship at an open public meeting. I have a quote here. If the people cannot trust their government to do the job for which it exists, to protect them and to promote their common welfare, all else is lost. And that was said by Barack Obama. Can you all guess what I'm going to ask for on the next agenda? I've asked for it probably 10 times now. And that's the fact that this board is regularly, and the Department of Consumer Affairs, so maybe Mr. Lay can ask for this on the agenda, you're regularly breaking the Public Record Act law. And I've asked for this to be put on the agenda. If you guys think I'm wrong, put it on the agenda and prove me wrong. I don't know why you're not interested in this. I'm finding facts where you're actually breaking the law. You should be concerned about that. And the fact that nobody is taking this and putting this on the agenda makes you all accomplices to the breakage of the law. Put it on the agenda. Let's talk about it and put it to bed. I think I can prove my case. The only recourse a public member has when they file a Public Record Act request, if it's denied illegally, is to file a lawsuit. I can't afford it, you guys. I made $2,000 last year because I volunteer 100% of my life as a public safety advocate. I can't afford a lawsuit. I can't sue you guys. So let's talk about it. I think I can prove my case. Please, put it on the agenda.
Okay. Thank you. Please come forward.
Hello, my name is Marion Hollingsworth, and I'm a patient safety advocate. What I'm concerned, Mr. Wormuth, is this sounds like not only censorship, but a freedom of speech issue. A lot of the people who come here have gone to the board before and have their complaints exhausted, and still nothing has happened. So we monitor the board to ideally make changes that will keep those doctors from harming other people. I know of a case recently where a doctor was finally has an accusation in a patient death, but another advocate had a loved one die because of this doctor, and it was turned down. So it finally took someone else to die before something was done. And we do, excuse me, we do what we do to protect other people that we will never know, but we hope that we'll make a difference in someone else's life because maybe will be listened to finally, and the doctor will be either taken out of practice or have education and made safer so that no one else will suffer the way we did from the loss of our loved ones or the loss of we're becoming disabled because of a doctor. This is what we do. We're not sitting there trying to make, at least I'm not trying to make an issue about any particular board member. I just want the board to be more effective so that the people of California will be safer. Thank you.
Thank you. Please come forward.
My name is Kamar Gill.
This is to request future agenda items.
Yes, definitely.
Okay.
My name is Kamar Gill, and I agree with what just Mr. David Wormuth said, because I believe the perception of the public in terms of what board can do and what board cannot do is very light. They don't have a clear understanding of it. I'm a physician, and we physicians are also entitled to due process by the law. If I did something wrong and board investigates me, the burden of proof has to be up to you guys to get against me to convict me of something that I've done. But a lot of times what I've seen with the processes and the budgetary cuts that you have, you're not even able to build a case against the physician, or physician have a malpractice policy and he's able to defend it, and it's as simple as that, you know. But coming back to something that I would personally want to be brought to the agenda is the role of the California Department of Public Health. I brought it, I discussed it in October meeting. It made it to the minutes of the meeting. But what I've noticed, and I'm sure from the communication I've had with the board staff and one board member at least, which was, by the way, not disclosed to the board yesterday when those disclosures were made. The communication, I'm trying to focus on the fact is it is very easy to blame an individual for doing something wrong, but that individual is not working in isolation. I mean, be it an RN or an LVN or a physician, errors happen occasionally because physician made a mistake, but mistakes also happen when it's a system-based failure. And what happens is when the system-based failure occurs in a CDPH licensed facility like a hospital or a clinic or any other surgery center, the matter automatically gets transferred over to CDPH to investigate, and which, for whatever reason, are not doing their job properly, and those issues are being closed. And even on the slightest hint of a physician involvement, they start a complaint against the physician when most of the mistake or most of the wrongdoing happened by individuals who were not licensed by the board. So the reason I'm bringing this up is to have a discussion or some sort of a clarity for the public that CDPH licensed facilities can be making mistakes, and it's not always the physician working in there who is committing all those errors and mistakes. So something of that nature has to be I've been told to the public as well. Thank you.
Thank you. Are there any additional comments in the audience? Any comments on the phone?
We do have a question from the phone. It comes from Michelle Monserrat Ramos. Ma'am, you may begin.
Hello, my name is Michelle Monserrat Ramos. I'm calling in from Los Angeles, California. And I have to say, before I make my comment, I'm incredibly frustrated. This is the second time today that I've inputted my request to make a comment in the queue, and my request was ignored. Twice. Yesterday, the phone line was cut off at a critical point of the meeting. Secondly, the reason why I'm commenting today is regarding the Department of Consumer Affairs comments regarding uniform standards. Most of you know the reason why I'm involved in this issue is because my late fiance died due to at the hands of a drug-addicted physician. Because of his death and because the board refused to investigate his case, I became involved in this issue and have worked on this issue for the past 12 years, being one of the reasons why the uniform standards even came into place. Number one, my first comment is Department of Consumer Affairs has made no effort to incorporate a teleconference line to allow the public and stakeholders like myself to participate in these meetings in real time. Number two, the change in the number of random drug testing, as Patrick explained to me, would only affect certain licensees. And I had asked him at the time that we talked to specify which licensees, such as pharmacy techs, respiratory care therapists, those licensees that are supervised 50% of the time. Now, for Patrick to mention the changes and generalize them, as was done today, to this board, makes it appear relative to physicians, and it really shouldn't be. Thank you.
Thank you. Are there any additional calls?
I show no other questions.
Okay. Thank you. We are officially adjourned. Thank you.